We likewise do not.
Any conflict exists, make way for the avoidance of all doubt.
Thank you. Mr. Brown. Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender. We likewise do not believe that any conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflicts so that this honorable court could hear these matters.
The court, thank you, sir. Court for its part also does not believe that a conflict exists either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case, People State of Michigan versus Charles Daniels. Charles Daniels.
Yeah.
For Douglas for the people.
The council stated.
No, he's still doing. It's on my end.
Counsel, you want to state your appearance?
Judge, I'm here. Can you hear me, y'all?
I can hear you now. State your appearance, please.
Hey, good morning, y'all. I'm Captain Patton, 710 on behalf of Charles Daniels, present from the County.
I don't know where you are. I'm having trouble hearing you. Mr. Daniels, can you state your name?
Charles Anthony Daniels.
Thank you. What are we doing on this case?
Judge, we're just setting this matter for a preliminary.
Is all discovery complete?
Our discovery is complete.
People have their witnesses available to 10. Preliminary examination in person will be set June 10th, 2025, 9 a.m. before Judge Barr.
Thank you, Judge.
Bond will continue. Thank you. Court does call the case of the people or cases of the people versus Shernoa Harris.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Edward Drupas on behalf of Shernoa Harris.
Harris. Hi.
Thank you, Your Honor. I'm still obtaining some discovery in this matter. I'm asking for an adjournment.
All right. Today's 29. Probable cause conference will be adjourned to June 12th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, it's come to my attention, the defendant has been contacting the victim through jail calls. One call specifically is cause concern. She asked her to get a PO box that she could send mail to. I have concerns for her well-being, as well as the defendant violating her bond. So I'd ask that her phone privileges be revoked as well as her mail privileges.
Response.
Your Honor, I haven't heard any of the phone calls. I'd like to obtain those prior to making any decision.
The issue with the mail, certainly we will let the jail know. The revocation of that becomes somewhat of an issue, but they do have a way of figuring that out. But at this time, what I will do, and certainly, Mr. Drukas, you can request a hearing. I'm going to grant the people's motion. Defendant's phone privileges shall be revoked. Pending a hearing. Thank you. 12.
Thank you.
Thank you. Let's call the case of the people versus Andrew Patton. It's just that case.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Christina Costantino. On behalf of Mr. Patton,
Where is he?
Unfortunately, Judge, his whereabouts are unknown at this point. I know there was some confusion as to,
Oh, I had no confusion. I don't know.
I'm sure you.
I don't know who else decided they had some confusion, but I had no confusion. He is supposed to be my guest at the Washington County Jail, and he is not.
Yeah. You need the approach on this matter.
Of Mr. Priester.
Priester, can you state your name, please? Pardon? Thank you. What are we doing?
Your Honor, in this case, Ms. Constantino was actually just getting ready to discuss with Ms. Barnwell for the co-defendant, whether they wanted to potentially set a joint or separate exams. And I think we wanted to set it out a bit, if so, because there's still some discovery coming in. So I'll leave that to Ms. Barnwell. They haven't gotten a chance to speak yet.
There's still outstanding discovery.
There's still things coming in. They had some search warrants out, and I think we're still receiving additional supplementary.
All right. What do you want to do on this, Ms. Barnwell?
I think set it out for an exam date.
Okay, but if any discovery you don't have, that's not going to be a basis for an adjournment.
Okay.
You understand that? Ms. Constantino, are you going to be doing that with your clients?
Judge, we can do that. I would just ask if we could get an exam date that was at least a few weeks out, because I know in particular, there is at least one report that we are waiting on that I know Ms. McDuffie does not have possession of yet that we need. So I don't know if the.
Are you
might make
aware of
more-
that report, Ms. Barnwell?
No, Ms. McDuffie was telling me about it just now.
I do. You guys figure it out, get it all together. I'm going to adjourn the probable cause conference, finding good cause to June 12th, 2025, 9 a.m. These are capital offenses.
I didn't hear you, Judge. What was the
June
date
12th.
for PCC?
For PCC, these are capital cases, you need to have all of that information.
Thank you, Judge.
Thank you. Court calls case People versus Larzelle Washington.
APA Richard McDuffie for the people.
Good morning, Your Honor. Edward Drukas on behalf of Larzelle Washington. Approaching.
Your name, sir?
Larzelle Washington.
Thank you, sir. The court has before the plea form. Is that what we're doing today?
Yes, Your Honor.
The plea form indicates that the defendant would be pleading no contest to the charge of receipt and concealment of stolen property, 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct?
That's right.
That's correct, Your Honor.
And I have him sworn.
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
State your name.
Larzelle O'Neill Washington.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of receipt, concealment of stolen property, 200 to $1,000. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, two things about a no contest plea. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, sir.
Basis for the no contest plea.
Civil liability.
Sir, to that charge, how do you plead?
Guilty, sir. No contents.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. You'll see a copy. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of rights.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe, well, I won't ask you that. Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 24-62111. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt. Counsel, have I complied with the court rule?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be July 3rd, 2025, 10 a.m. before Judge Washington.
If I may address Brown, Your Honor.
Go ahead.
Mr. Washington previously was remanded for, or I had been picked up for a warrant for failing to show up to court. I have had several discussions with him, gone over this case, gone over what happened at his sentencing. He did interview with the recovery court. And now with him going to 14B for sentencing, I'm going to assist him with getting the paperwork ready for probation. He knows he needs to make and keep an appointment with probation. We're not objecting to any additional orders the court would impose. If the court would require him to test at community corrections, he would abide by that. He reports to the court today that he would show up to that sentencing, that he's tired of being tired, and he wants to take care of this. So we're asking for a PR bond. He has spent about 30 to 40 days in jail since he was picked up. And I think he understands the consequences of him not showing up to court and the fact that this was reduced from a serious felony to a misdemeanor. We're asking for that reduction to a PR bond.
Response from the people.
Thank you, Your Honor. So my only requirements for the reduction in this case was that Mr. Washington participate honestly in the screening and referral process for the treatment court. I believe the court had the outcome of that screening interview. I don't have the full assessment report, but I wanted to get some sense of where he is. I have not taken a position on him being released thus far. The only request that I have is that he be ordered to test for drugs and drugs specifically, alcohol, I suppose optional. Especially given the outcome of the interview, Mr. Washington is very adamant about not participating in treatment court, so I do want to ensure that he at least remains compliant.
Yes.
Bond will be reduced to a $25,000 personal recognizance defendant to test 2 times per week at community corrections. You understand that, sir?
Oh, yes, yes, sir. And thank you, Justice.
Well, don't show up. I don't know if Judge Washington would be so generous.
I'm gonna
Show up.
Sure, sir.
All right.
Thank you.
You got to make sure that you test.
Ashley McKinney first.
You're not calling name of what you got to respond.
Ashley McKinney is called in cause number 25 CR 292, no answer. In the courtroom, I asked the bailiff to call into the hall for Ashley McKinney. Ashley McKinney, please. Thank you. No response according to bailiff's call out in the court, in the courthouse hallway. No answer to that name being called here in the courtroom. Defendant has failed to appear. A warrant shall be issued for her arrest.
Bond's $50,000.
50, 50.
50.
The bond is doubled to $100,000 plus she must have a GPS device attached to her, so we know where she is when she's not in court, like she's supposed to be. Kyle Tackno.
That's a plea, Your Honor. Kyle, are you
25 CR 220.
two cases?
Speaking to both.
Yes.
I'm just waiting on paper.
You are Kyle the Montagno,
Yes, good.
present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive formal readings of these indictments and the arraignments here? Can we proceed in summary?
Yes, sir.
In summary, each of these indictments similarly allege state jail felony offenses. In 25 CR 420, it is alleged that on or about March 8th, 2025 in Jefferson County, Texas, you committed burglary of a building. And also on that day in Jefferson County, Texas, it is alleged that you also committed the state jail felony of criminal mischief. Each of these state jail felonies carry with them no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand? So
Yes, sir.
what's the deal on this?
Deferred plus restitution
Of 5 years, up to 5 years?
up to yes.
All right. Agreements have been reached where you be pleading guilty in each of these cases, placed on 5 years deferred or unadjudicated probation, which will run concurrently together. And if you do well, then it's shortened to 1/3. Is there any fine?
No,
Any,
there's restitution.
no restitution.
There is restitution.
Restitution is $15,000, $767 and some odd cents. I just sent it.
On which case?
On the criminal mischief.
Again, restitution is in the amount of 15,000 what?
$15,797.76.
15,797.76. And that's going to be ordered as a condition of probation. That's going to keep you busy paying that back. You're going to need to pay that back. If you don't, your probations can be revoked and then you can be sentenced up to 2 years in each case. Do you understand?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in each of these cases? Guilty or not guilty?
Good.
Are you pleading guilty in each case voluntarily and because you are guilty?
Yeah.
Yes?
Yes, yes.
Okay, she needs to take down. I'm going to show you here what's marked in each case as State's Exhibit 1. And at the top, did you sign those documents, understand them, discuss them with your attorney, or the contents all true and correct?
Yeah.
State's Exhibit 1 in each case tendered into evidence without objection admitted. Among other things, these states Exhibits 1 in each case state that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer in each of these cases. All of this is true, so help you God.
Yes. Oh, thank you. Yes, sir.
State's Exhibit 1 made a part of the record in each case. And the court will make findings in support of what the court has just read and has been acknowledged by the defendant. And Pre-sentence reports away.
It is.
I'm going to follow these agreements, if nothing further, and find you pleaded guilty in each of these cases voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty in each of these cases beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any finding of guilt so long as you follow these terms and conditions of probation that the probation office is about to go over with you. Make sure you do. They're real simple. They're pretty much rules that we all have to follow,
Yes, sir.
even me. And let me ask you on this, are you working somewhere?
Yes, sir.
How much are you going to be able to pay toward restitution a month? I know you probably don't have
Like
$17,000 handy,
Yeah.
but you're going to have to get this paid back. And until you do, your probation will remain
Yeah.
open, and you want to move on with your life quickly as possible.
Yes, sir.
So how much do you make an hour?
Well, I work it. I should be like 150,
How much are you going to be able to pay a month towards this
Mhm.
restitution, sir?
like 200.
Okay, and again, the restitution is attached to 25 CR 421, the criminal mischief, and it's in the amount of $15,797.76. How much did you say you can pay a month?
Like 200.
That will be required at least $200 per month. And if you have problems with that, you've got to talk to your probation officer and let her know, okay, or him know. All right, anything else? Fix this. Fix this. Don't do something like this again. Go see the probation office. Thank you.
Yeah, I'm not. I don't. This is furniture version. Something like that. Try to I have every time that he wants to even know I'm like that. But I guess you're. Yes, he did for me. He was very hard.
You're pretty good.
You're going to dress, sir, please dress outside. Next thing you know, you're going to be putting your underwear on here in the middle of, in front of everybody. We don't want that. Did you use some deodorant spray too? When you, okay. Oh. So turned into a dressing room. Courtroom turned into a dressing room. Cody Wilson?
It's a plea as well.
Thanks, Don.
Doing the best.
You'll do the best you can. We're gonna move them. And you are Cody Wilson?
Yes, sir.
And you were here with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of this indictment in 24 CR 2002? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about April 21st, 2024 in Jefferson County, Texas, you committed a state jail felony of theft. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face no less than 180 days up to 2 years in state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement has been reached in your case, sir, where you would be pleading guilty. And placed on deferred or unadjudicated probation, which can be up to 5 years in length, fine $500. You do well, he gets shortened to 1/3. What's 1/3 of 5? It's about a year and 2/3. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Yes.
Are you pleading guilty of voluntarily? That is on your own free will and because you are guilty.
Sir, you plead guilty of your own free choice. Yes, sir.
I show you what's marked as State's Exhibit 1 there. Did you sign that voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tender.
No
Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were given your rights to a jury trial and allowance to appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true, so that you got. State's Exhibit 1, part of the record for all purposes. Pre-sentence report.
Yes.
I will follow this agreement, sir, and find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. From State's Exhibit 1 here admitted to find you guilty beyond a reasonable doubt. However, I'm going to defer any finding of guilt so long as you follow the terms and conditions of probation that the probation officer is writing up. Make sure you do. If you fail, your probation could be revoked and you could be sentenced up to 2 years in the state jail. We don't want that. There's going to be a fine of $500. There will be terms and conditions of probation, which are normal and customary for this. There's no restitution.
No. No, sir.
Okay. All right. I'm going to sign this and you'll talk with the probation office and begin a probation immediately. The quicker you're on it, the quicker it gets finished.
Thank you.
And thank you. Thank you. Yes. Here we go. I've got it. Case 24 CR 519 has been sent to the court. It's a motion to dismiss on Patrick Leach. I'm signing it. That case is dismissed.
Thank you, Judge. Appreciate it.
Next is Tiffany Duraso. I think that case 25 CR 316 has been reset. The defendant has hired an attorney.
I have no knowledge of that, but I don't.
That's what this is saying. Somebody would have written it, probably who knew what they were doing when they wrote it. So that should take care of. I find good cause to release you, David, from further representation. Braden Hensley is next, 24 515.
Get that in your pocket. Yeah.
All right, what are we doing here on this one?
In fact, this is his initial appearance.
It certainly is. It doesn't mean it can't get moved if everybody's ready to move things.
I haven't had any time to talk yet.
You're charged with a 3rd-degree felony, a physical possession child pornography, it carries with it up to 10 years in prison. So you got to deal with it responsibly. Mr. Grove is representing you.
Judge, you need to fill out.
I guess so.
Are you able to hire a lawyer?
Not right now, but I know I can. I started this job.
You're filling out this right now, and then it's an individual form.
You know, so he's still not right here.
All right. You can't get any adult clients?
I don't know.
Anyway.
Anyway,
Anyway,
anybody, Judge.
he's gonna fill that out. Don't mess with this county.
I'm not saying anything further.
Mr. Wade, you want to go get a switch? John West just brought one of his younger clients in there in the back.
I saw that. She paid him with candy.
Gummy bears.
From Halloween.
He's got gummy bears.
And she listen to this. Liz, you might have to testify.
When you, Mr. Hensley, when you're finished, let me know, okay? Come up, swear in front of this lady, I'll review it, and then, David, you're gonna want to put this on an announcement right in 4 weeks?
Yes, sir. That's what I recommend.
Okay.
I received discovery, but I need to call.
Jack, is it Jackie Williams? Jackie, is that an I or an L? Jackie Williams, is that you? How do you pronounce your name?
Regular Jack. There's no copies.
Okay. Mr. Grove is your attorney.
I'd like to work about 4 weeks. Good. About 2 cases.
Okay.
Just fill out that religious one.
Are you, okay, he's appointed to represent you because it's showing that you might be indigent. You need to fill out that financial form for me to decide if you're unable to hire a lawyer.
Okay.
You can hire an attorney anytime. He's a very good lawyer. If you're unable to afford one, we can supply Mr. Grove to help you until you can hire somebody, okay?
Okay.
Fill that out, and then bring it back up to her when you're ready, then I'll review it. Austin LaFleur, that was Reese, that he has hired an attorney. You know. Here are these.
What's in my
Tiana Baker.
handful of files?
Tiana Baker is called. And cause number 2561. Hold on, hold on. Yeah, we asked the bailiff to call into the hall for Tiana Baker, please.
The attorney is from out of town and he was here.
He
He
is
just
here?
went outside, so.
I apologize. I'm scared of this later. He's, I'm walking into the courthouse right now.
Okay.
I have approach.
Yeah. They were trying to, we're a little ahead.
I apologize about.
For being ahead?
No, I
Oh,
can't hear. I just stepped out when you called it.
Yeah, what do you want to do today?
Judge, I think I need to work on it. We have been communicating, Judge, this is a case that. Yeah.
You've been communicating. What do you want?
If you get-
Are you Tiana Baker? No. It happened for 4 weeks, good?
Yes, sir.
Okay. All right, when she gets up here, we'll just get a resetting for, okay? Okay, just stand by. She should be showing up.
Yes.
Justin Woods.
Here. Yeah. Here.
Are you Justin Woods? You're Justin Woods?
Yes, sir.
Okay. 24 CR 2411. Do you have an attorney?
Yes, he should be showing up.
Who is it?
Bill, I forgot his last name, but Bill is not there.
Cheadle? Cheadle?
Can I look at my phone?
You know, some glasses.
Somewhere.
I think it's Cheadle. Where is he from Houston?
Yes. Yes, Cheadle.
Okay. When was the last time you talked to him?
Just a while ago.
Oh, he's here Sunday.
He's on his way. He's running a little.
Oh, you had him on the phone?
Yes, sir.
Yeah, just stand, just sit by and when he gets here, let me know, okay? Because I'm not sure I know what he looks like. Ashante Victor?
This paper's here, you want her to stand up, it's not.
What do we, she needs to, sign a resetting.
Yes, Your Honor, I just want to let you know she's.
Yeah. Hey, Don Dusler on Dwayne Francis.
I call his name, no answer.
No, fairness, I gotta wait a few minutes. What about Terrence Killings? Mr. Killingsworth?
I saw that now.
Yeah, just back down the front row.
Okay, come on.
Yeah, let's follow.
Yeah, let me go to somebody who's here.
Yes.
Signs.
Okay.
You're Terrence Killingsworth.
Yes, sir.
Mr. Dusler was appointed to represent you. Have you hired Mr. Kimmer? Okay.
There should be, this is a representation.
I don't know, but it's set for an announcement. What do you want to do today?
Safe.
Come up here. Let me talk to you about something. Weeks resetting on Mr. Kimmer's case on, I've lost him. What is your name, sir? Killingsworth. That's right. It was Mr. Dusler and didn't you?
On the previous case, called Dwayne Francis, he is here. And he's advised me that he's hired James Patchett, who knows to be.
Where is he? Where is he?
Very back.
Come on up. You hired somebody? You hired somebody?
Yes.
You're Mr. Francis?
No. Yeah, that's practice.
Dwayne Francis? That's you? Okay, you've hired somebody, a lawyer?
Yes, so I think it's
James Paget? Where is he? Have you seen him?
Well, that's what message I read. And then there's
Can you? Yeah, can you go, Ellie, to call James Paget? We're waiting on him. This client is here. He's supposed to be here. Thank you. Okay, just stand. Thank you. John Lawry.
And I've called his name, no response.
25 CR 125 is called John Lawry. There's no answer in the courtroom. I ask the bailiff to call into the hall, please, for John Lawry. Thank you.
What's the last name?
Lawry, Laurie. Lawry. No, I don't have,
No response, Your Honor.
I don't have him in here. John James Laws. Should be right after the Killings. You know, and I've got the Killingsworth. And here's Laurie. Okay. There is no answer in the court, no answer in the hallway as called by the bailiff. The defendant, John James Laurie, has failed to appear in this case. His bond is
$10,000.
10,000. It is revoked. Now it is $20,000 plus the defendant must have a GPS device as a condition of bond. A warrant is issued for his arrest.
Judge, it's the last case I have. Do I need to wait? I've had it on the previous.
Okay.
Thank you.
Sean, is it Cody or Baco? Baker? Mr. Grove, you've got Sean Michael.
Yes, sir.
How do we pronounce your name? Baco. You're charged here with the state jet felony of operating a motor vehicle in a public place with a child passenger, which carries with it up to 2 years in the state here. What are we going to do?
I'd like a little time so I could investigate some additional information I could supply today. I think we will be able to close the case, Judge.
Well, I hope so.
I just need a little bit of time.
Is 3 weeks good?
That's good, Judge.
Okay, reset 3 weeks. You please get a resetting. Thank you. Let's see. Cody Washington, 4 cases there have been reset. I think it's West there in this party.
I'll let it export.
Need some more files?
Yes, sir.
Get what I have for here.
Afternoon, how are you? There you go. Oh, other.
Sir. Oh, that's.
God bless you.
Thank you.
There is an add-on on this page 3 at the bottom. It says Lamarian Bean, but I don't have that file in this. Lamarian.
Right here, Judge. Sorry. It was on the bottom of the stack.
Is Lamarian Bean? He's in custody.
Yes, sir.
Do we, what do we need on this, man?
This is a case in which he was on his way to court and actually went to, and his family members here will say that he actually complied with the court's order. He then came back up here, apparently didn't get checked in, so he was arrested. He's been in jail now for about 2
He
weeks.
didn't get checked in. What's that mean?
His case was not reset. I'm not sure, Judge. I'm just saying if he went to jail, he showed up for court on that day. I spoke with him on that day. He then later was arrested.
I still don't understand.
There's not a bond on him, Judge. I don't think the court has set a bond because you haven't had a bond hearing or anything of that nature.
On February 4th of 2025, there was an affidavit of surety to surrender the bondsman, Stan Stanley. States the defendant has refused to report as required. He's failed to appear for his municipal court, does not have a stable address. This bond is at risk. Request a warrant so that surety may recover the defendant to custody prior to his court date.
This was something from
This was back in February, so I ordered a warrant to be issued and a hearing upon the defendant's arrest.
Judge, I believe Ms. Jordan probably knows more about this than anybody else. But Mr. B did appear in municipal court as ordered.
But somebody's got to, the court makes findings and this reset ASAP, the bond to be set, defendant is in jail with no bond. This was on 5/21. So I guess that's what this hearing is on.
I believe it is, Your Honor, and Ms. Dean?
Yeah, bring him out, Tommy. Thank you.
There's a public safety reports in the Judge 3. I think from previously. I think I'm not.
Yeah, no, it's not. It's completely present. We have to turn them off and back on every time we do it.
Yeah.
They're on.
Yeah, I did double charge the loss today.
Yeah, I don't think it's there.
Yeah, it was.
No.
Is it just say like person needs fingerprint or something like that? I'm just.
They go, so you have to turn them off, come back on.
We over that very hard way feel about the basis. So we're very resolving.
As Mr. Meany's been in jail, I've talked to him at least twice.
Hold on, let me finish reading this.
Yes, sir.
Thing.
Is right now. Friday's job. Sure is very. Sorry, from yesterday. Yeah.
I always do it in the office.
They're related to each other.
I never asked them.
It's the same issue as employees. Yeah.
All right, let's see. Defendant in 24 CR 2413 is the state of Texas versus Lamarian Bean. Is that you?
So.
Yep, speak out so she can hear. You're here with Mr. Grove, your attorney, and the state's attorney. You're charged with the 2nd-degree felony of aggravated assault with a deadly weapon. Okay, go ahead, David.
All right, Judge, somehow, and I imagine I was partially to blame for this, although I'm not real sure exactly what happened. Mr. Bean was set to go to court on I believe on the 21st
Of what month?
of May. And he did not go to court at the time. He actually had been told by someone at the court, and it wasn't me because I didn't know about the hearing. He also had a hearing at the Beaumont Municipal Court.
When?
And I believe that would have been on the same day, well, I'm not sure. What, did you have a court date in the Beaumont Municipal Court? Do you remember when that was? Sorry. You came to court here.
What day?
What? Are we talking about November the 13th? Or that, because that would have been last year. That's when this offense occurred. Or February the 13th? You actually went to court, is that correct? All right, what happened over there? They said it was a warrant because you're not here to get a Stevens court.
So I figured it's in the good those to the bed.
Man, that's not right. No, I got all the documents. A warrant was issued for him on February 4th. And there was his bondsman submitted an affidavit to surrender him because the defendant refused to report to the bondsman, has already failed to appear for his municipal court date, does not have stable address, and the bond is at risk, requests a warrant. So a warrant was issued and the court ordered a hearing upon his arrest. I don't know when AFRS, no bond forfeiture. And actually the court ordered a $60,000 bond and a GPS device on 2/13. Defendant was taken to jail on 2/13. Set 2/25, an announcement. And the court notes the defendant in jail. Then on March, I reset it for March 4th for an announcement on March 31. Just keeps getting reset. Somewhere. The last one is on 5/21. It was this court set it for, I'm sorry, on 5/12, I set it for 5/21 on a hearing on the bond issue. I don't know what happened, but on 5/21.
I believe, Judge,
And we reset as soon as possible for bond to be set, and that's that's the third or fourth time I reset this with exclamation points, which means it's not being done, and there's a time factor here. So now he's here. I don't know what took so long.
Has he been under bond conditions
No.
at any point?
No,
because he's jail, Judge.
No, I know he's been in jail, but we keep resetting it to get him up here, and he's not showing up.
I'm gonna make the court aware that from the jail, he's been communicating with the complainant in the case quite a bit.
Judge, he's been in jail. He's been in Jefferson County Jail since the day he was first arrested in this court. He hadn't been anywhere else. Now, I don't know why he hadn't been getting up here or what the situation there is, but he hadn't been brought up here.
They were still every time.
I know, well, hold on.
I think last week.
That's fine, David, but you're his attorney. Somebody needs to make it known to me that there's a problem. I've got 5,000 defendants. I mean, we're trying to get everybody done, but
Yes, sir.
somebody's got to wave the flag, and because this doesn't happen normally.
Last week, Judge, it was Mr. Grove had to leave early from court, and that's why we didn't get to reach this hearing.
Okay. All right. So time for bond. He's here.
Yes, sir.
Let's move forward.
Further, Judge, I've been provided with 4 telephone numbers by Mr. Baines, and I've called all 4 of those more than once, hadn't been able to get anybody from his family to talk to about why he wasn't here. But I do have 4.
He's here.
Yes, sir. And I
Go
don't
ahead.
know why I had.
Go ahead. What do you want?
So, Judge, I think if we could ask the court to set a bond on him, I believe he did appear on the day he was supposed to appear, and he has been in custody for some period of time. And I'm sure that there's many things I should have done and I didn't do, obviously, so I apologize to the court. But
Let's go. What do you want to do today?
I'd ask the court to reinstate his original bond
Why?
that he had in this case, because he has made all of his appearances as far as, in fact, although I think technically he did not re-sign it. On the first time he was brought down here, which I believe may have been February the 13th. He had been arrested the night before and was very upset. And some of the bailiffs, some of the female bailiffs spoke with him and calmed him down, but he did not appear before the court on that day. And I believe that he did appear, but he didn't. And I believe that's from the original.
What was the original bond?
Didn't belong to 30,000.
I don't think that's sufficient.
And then the bondsman got off of, it was $30,000. The bondsman, that was made on the day after Christmas.
Yes, sir.
And then it says the defendant's refusing to report as agreed weekly, failed to appear at his municipal court date, does not have a stable address, the bond is at risk and requests a warrant. That was on February 4th. And that's what, that court granted this affidavit of surety to surrender with an order having a hearing when he gets arrested. For some reason, my order was not followed back. Stand just 1 second. Okay, I think I understand where we are here. Go ahead.
One other thing that, and I was bringing this up, but I believe since he's been incarcerated so long that I think he will show up. Mr. Eckhart indicated that the defendant had been contacting the complaining witness. I have no knowledge of that, although the complaining witness has called me and has spoken to me in this case. So I can believe something like that happened. But I'd ask the court just to consider reinstating his bond. And I apologize because obviously most of this was my fault because I did not ask for a bond earlier. I should have been able to get in touch with his family, but he could not.
Okay, who have you talked to?
Early on, Judge, I talked to Mr. Baines' girlfriend or wife.
Who is
Ms. Gassworth. And she was still living with him. They were living in Jasper the last time I spoke to her, but I've been unable to get in touch with her. I've also spoken to his mother on one occasion.
What's that person's name?
Shaw. Shaw. And Ms. Shaw.
What was that first name or last name? Miss Shaw.
And but I haven't been unable to get in touch with her. I spoke with Margie Matthews, who is the complainant, and at the time of the incident, he was actually staying with Mr. Bain and his wife, but when I spoke with her, she was staying at a different location. And I don't have that address. I just had a phone number that she calls. And then also they gave Miss Gassaway, he gave Miss Gassaway his phone, but he was arrested. And I've tried to get in touch on that, and that has been disconnected. And I believe that was Miss Gassaway that had that.
Okay, well, so what is the point you're making on this?
Judge, I would ask the court to reconsider reinstating the original bond because he was placed in jail on. He was arrested on a warrant, I believe, probably on a bond that had been set by a justice of the peace, and then was in jail, got out before he ever actually went to court, I believe. And then was arrested when he came up to go to court. And there hasn't been a bond since that time, I believe. I may have left a couple of things out.
Go ahead. What's that say?
I think if you take all this, all these other procedural problems out of the equation, I would still be thinking the bond is not sufficient. So that's really where I'm at here now, based on everything I'm seeing. Well, because of the fact that if you look at what is in the probable cause affidavit, combined with the fact that we know that he's been communicating with one of the victims present at the scene, Gassaway.
Gassaway was not one of the. Gassaway specifically gave a statement to the Beaumont Police Department that she did not wish to file charges and was not injured.
She also didn't dispute anything that the sister said. She just said she didn't want to file charges. So I have a very big concern here, given that this is the type of situation that easily escalates, and we come back here and we're dealing with something else.
Even more interesting, Judge, it is not a sister, it is a stepsister, or I'm not sure they have a blood relationship between the two of them, but they're not living together.
I just don't think that really matters for purposes of what we're here to decide.
What do you understand? Who is the defendant reaching out to from the jail?
Gasway, the wife that did not want to file charges, but I fully intend to call as a witness if we have to try a case.
And she is not a victim in the case, nor is she listed as a victim, although she was a witness. I thought you were talking about Miss Mack. I've spoken to both of them, but.
She is not the named complainant, but she easily could be. I could file another charge with or without her permission.
You want me to read out the probable cause affidavit? That's what we're relying on here. You want me to read this out? I'll read it out so the whole world can understand. So we've got, the police make contact with Gasaway and Matthews, two females. Gasaway states she was having an argument with the defendant, which led to him coming home locked out of his residence. Gasaway states the defendant broke the door down and Gasaway and Matthews run to the bedroom of their apartment. They both stated they heard the sound of a gun being cocked. The firearm was discovered inside their residence. Matthews stated she observed the defendant point the firearm directly at their heads. Gasaway and Bean, the defendant, began a verbal altercation, which led to Bean, the defendant, grabbing Gasaway by her neck and pinning her to the wall. Gasaway stated the defendant then body slammed her on the bed and held her down. She was not able to freely move. Due to these facts, Bean was arrested, the defendant, for the above charge and transported to the Jefferson County Jail. Okay, that is what we're relying on here. That's the probable cause affidavit signed under oath by Beaumont Police Department, who investigated the case. The defendant is charged with intentionally or knowingly threatening Matthews with imminent bodily injury and used and exhibited a deadly weapon, namely a firearm, during the commission of the assault, which is in line with the probable cause affidavit. What is the indictment did not, there's not an indictment stating that Gasaway is a complainant in a formal indictment.
That's correct, Judge.
Okay.
I do think that we should have a bond condition addressing that right there, just because we know he's been in contact with her.
With whom?
Gasaway.
Okay, what about that? Mr. Reed.
Judge, we can get into the entire fact situation here. It was his apartment where the incident.
No, I'm
took
talking
place.
about the communications he's having with Gasaway.
I don't see how that is disobeying any order of the court. What he has 4 children, 3 children.
Wait.
It's not what I said.
Wait.
Okay.
Hold on. You don't think that's a violation of any order?
Well, contacting her alone made
What do you think?
plus, I don't know how he contacted her, but I'm assuming it might have been by telephone. It could have been that she came to see him at the jail because local, but I don't believe, and I'm sorry, I'm probably misinterpreted the point that the prosecutor's trying to make in that.
No, so we're talking about setting bond conditions. Let's get to a bond. We're talking about setting bond conditions that the defendant would follow of orders of the court. And what I'm saying is on Matthews is the complainant in this indictment.
Yes, sir.
But what about the communication he's been having with Gassaway?
All right, that's what I was very inartfully trying to address, Judge. As a result of this, Ms. Gassaway basically moved back to Jasper, where she was living with Mr. Bean and 3 children.
I know, I'm talking about since the incident, since he's been arrested. But I think her relationship with Gassaway.
I don't think that he has threatened her or anything.
He's communicating with her.
Well, I'm not sure. I wasn't sure. I didn't understand that he was communicating with her.
I thought that's what this.
Yes.
No, I mean, Mr. Eckhart said that he was, and he has more access to the jail phone calls. I didn't know that until this morning.
Yeah, I didn't either. I just looked it up while we were here.
Well, what is it that you know?
Approximately 50 messages back and forth. There's probably phone calls as well. Yes.
Oh. Here's the problem. Okay. I'm taking the word of the prosecutor, and he's a court official just like you. And I'm going to present. Okay, you're not disputing.
I'm not saying that he's not.
I've got to set some orders that he can follow, that I can trust he will follow. Here's a magistrate's protective order.
Yes.
That was signed by the magistrate that says you shall not contact or have any contact with Gassaway. If you're going to violate this judge's order, you're going to violate mine. I'm sorry. It's an order that's in the record. Mr. Grove probably didn't know that because this was signed at the time of the event.
I apologize.
And here it is. You can have a copy of it. And it says, among other things, you shall have no communications with Gassaway. And this is signed by Judge Hughes, who signed this protective order on November 3rd of 24, and it's still in effect.
I don't dispute
He
that.
can't follow a judge's protective order. Why would he follow mine?
Again, I apologize. I didn't know that he had been contacting Ms. Gassaway because when I talked to him, he hadn't contacted Ms. Gassaway. Had been able to.
All right, we're going to move along.
Okay.
So the court finds that I'm not going to set a bond at this time because he can't follow a judge's protective order. He's not going to follow mine. And until you start following, and until you quit interrupting me, until you quit interrupting, you will stay in jail.
Hurt nobody, you ain't going to nobody.
That's all. What are we going to do next, David? I'll set it for trial.
Also, let me see if I can work any kind of resolution, Judge, since we haven't even had a chance to discuss that. And if not, then yes, we'll.
Yes, sir. This has been one of those things where.
All right, see what you can do, but I'm just putting it on a review in 2 weeks, okay?
Yes.
Review in 2 weeks. Thanks. Caleb Landry. Yo, Caleb. Mr. Landry.
Yeah.
Nobody wants to be in jail. That's correct. Okay, Caleb. He's charged with burglaries of a building, right? And it's a 2-state jail felons. Okay. Yeah, what are we gonna do today?
get with Mr. Ham and see if I can get an offer and see if I can figure this out.
See what you can do. Thanks. Get back to it. Thank you. Kashan Washington. Kashan Washington.
Kashan Washington.
That's criminal mischief. That's an MTRP. Announcement. Kashan Washington, are you here?
He's in custody.
He's in custody. We need him. Kashan Washington. What we're gonna do.
I can just see that, if they want
No
to.
show, no bond. Yeah, he didn't appear for this first amended motion to revoke probation, so. Can we have a hearing on it?
Yes, sir.
Today? Okay. We're gonna, let me hold that and get back to it after I get this other stuff, okay? All right. Because we say it's administrative. Thank you. We're gonna bring him back in a little bit. Thank you. Zachary Broussard, Reagan.
He's here, I have not finished the paperwork.
Is it filing up today? Is it?
It's a financial issue.
They came in and they were working on it. They always fix it. They can always fix it because they're like doctors. How we doing on it?
Doctor's out.
Unfortunately.
We just need to shoot it,
Yeah.
put it to sleep. The heck? This thing is been, this is a different thing too, and it's dysfunctional. It's the best way to say it.
I gave you some new ones. Mine's are new.
What can
These
we-
are new, but they're not.
What can we, are we able to do anything though today effectively?
No, today it's just.
I got a plea
To
in.
get by today, Judge.
Huh?
Just gotta get how to get by today.
Oh, no, how do we
It
get by?
does work. It's
Oh,
just,
okay.
it hangs up in between, but
Yeah.
it works.
All right,
It's
good.
just how the pain.
Okay,
Just be
Miss
patient with them.
Kashan Washington? No,
That's the one we're holding.
Zachary Broussard.
That's one.
Where's he? Oh, he's in custody?
No, he's outside.
He's outside.
Waiting for me to come sign up.
Okay, I need you to sign. When you're ready, let me know.
Yes.
Okay. Christopher Harris?
He is here. His plea paperwork is complete.
Okay, we can do that. one.
Yes.
Maybe. Christopher Harris, come on up. Everybody grab a hold of something. See what happens. 25 CR 75, Christopher Harris, that's you, sir?
Yes, sir.
Does he need to sign in front of you or anything?
Is it a plea?
It's a plea,
Oh, okay.
and nothing but a plea. So help me God. Does he need to sign in?
Yes, he needs to come swear in front of me and fingerprint. He's supposed to be fingerprint.
Swear in front of her, don't curse.
I can handle it, Judge. Mr. Harris, please raise your right hand and swear or affirm to the truth, truth, and nothing but the truth, so be God. Okay. Ink up your right thumbprint, right. False. Place it flat right there. Keep it up one more time, make it a little larger. Scan this. Right. Okay, you go stand for the judge.
And 25 CR 75 is called the State of Texas versus Christopher Ray Harris. That's you?
Yes, sir.
With your attorney, Ms. Manaldi, and the state's attorney, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about December 9th, 2024 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon, namely a firearm. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation for up to 10 years in length, fined $500. There will be terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
I'm going to ask you to look at that. Did you sign that document, States Exhibit 1?
Yes, sir.
Discuss it with your attorney or the contents true and correct? Yes.
Yes, sir.
States Exhibit 1 tendered into evidence without objection?
No objection.
Admitted. This states, among other things, that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All true, so help you God. Yes, sir. States Exhibit 1 made a part of the record for all purposes, and the court makes findings that those stipulations are in the record, and the court accepts those as true and correct made by the defendant. Pre-sentence report, Wayne?
Yes, Judge.
If nothing further, I'm going to follow this agreement, and I find there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, but I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 10 years. You must pay a fine of $500. You do well, it gets shortened to 1/3 of that. There will be terms and conditions normal and customary that the probation officer is going to memorialize in the order. You will be fined $500 as well. You understand what has happened today, sir? Good luck to
In
you.
your honor, just for the record, the defendant, we've asked that he have no contact with the complainant in this case, who I believe he lives in Louisiana now anyways, but just for the record for probation, that he not have any contact with Michael Bouton.
Okay. Do you understand that?
Yes, sir.
And that's already been an issue in another case, and we want to make sure that there isn't more problems that develop. Let's fix what we've got here. And Michael Mouton. See, condition 27, you're going to go over these conditions. Condition 27 states, have no contact with the victim of the offense, either in person, by telephone, mail, electronic mailing, social media, or through a third party or any way else. So that takes care of that.
Yes, sir.
And that's in every case. So you don't want to lose your probation because of that. Here. Thank you. Court assigned these orders. And you are on probation, good. Thank you. That is my fault.
These books, which they were David's on the initial, and they, once those are approved, they.
Who is Jackie Williams? Come forward.
Judge, Miss McKinney, who was the very first person we called.
He was here earlier. We had him sign a resetting. He just had to fill out that affidavit.
All right, it's approved. I find the defendant indigent and attorney will be provided. And in Mr. Hensley.
You're good. He approved it.
Oh.
You're good to go.
Mr. Hensley.
Correct.
And I'm granting your request. An attorney will be appointed to help you. Try to see what y'all can do on getting that thing done and behind you.
Yes, sir.
So you can move on with your life until it's finished. It's hanging around your neck like an albatross. You don't want that. Thank you, sir.
Keep in contact with Mr. Ruff.
Vicky Holloman's case was reset. Javon Narciss.
Now we,
Mr. Narciss, come forward, please.
okay.
Javon Narciss.
He's a lead. She's bigger.
Mitchell Sylvester is reset.
He was reset.
Okay. And then I've got Patrick Leach next after this case with Brennan Mitchell.
Oh, that's what you're on.
Oh, that's dismissed? Did I read it?
Yes, sir.
Yeah, that's been dismissed.
Yeah, I've got one more, Judge.
Oh, okay. You want me to do another dismissal one?
I know.
I got you.
Can I get my last in? I'm not sure Sarah's gonna.
I'm sorry, John, not you.
Not me.
You're in the bad list.
my sister comes out, you would consider it.
Yeah, probably.
Denied.
Judge, I'll put on the show for a dismissal on it. Says that, okay.
Yeah, I've seen that and it's. Yeah, I want my money back. Yeah, the last one.
Jimmy, is this the last copy of this?
Yes.
Okay, thank you.
Who is this?
Javon.
Narciss, right?
Yeah.
Mr. Narciss. 24 CR 1940 is called the state of Texas versus Javon Narciss, who's present with Ms. Maldi. Your attorney and the state's attorney does the defendant waive a formal reading of the indictment and arraignment. Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about July 30th, 2024 in Jefferson County, Texas, you committed the second degree felony of robbery. Do you understand what you're charged with, Peter?
Yes, sir.
If convicted, you face no less than 2 nor more than 20 years confinement in prison, and fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty based on deferred or unadjudicated probation for 10 years, which can be shortened for good behavior. Fined $1,000. Terms and conditions which are normal and customary for that type of offense will be applied. Is that your understanding?
Yes, sir.
And if I follow this, you have no right of appeal of your case, and you understand. How do you plead to this charge, sir? Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct? State's Exhibit 1 tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea as freely and voluntarily made. You know what you've been charged with? The indictments can go to you. You were guilty of the crime charged in only lesser included offenses. You were given up legal rights to a jury trial and the rights to the appearance confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All truth so help you God. State's Exhibit 1 made a part of the record, sworn to by the defendant, and the court will make findings that into the record that are in accordance with those stipulations, waivers, and judicial admissions in State's Exhibit 1 that is offended has acknowledged, and I find are true and correct. Present truthful way.
Yes.
I'm going to follow this agreement and find, sir, nothing further. You're pleading guilty today voluntarily. You're mentally competent, so you understand and appreciate the consequences of pleading. There's sufficient evidence supporting the guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, but I'm not going to find you guilty. I'm going to defer in finding of guilt as long as you follow these terms and conditions of probation that the probation officer will make sure you understand. There'll be a fine of $1,000 and other terms and conditions, which is for normal and customary for this type of offense. Make sure you follow this, okay? Thank you. Yes, sir.
Judge, Mr. Parker wants to know if you'll take his plea next.
Who?
Mr. Parker.
No, anybody. Okay, thanks.
Thank you.
Alan, where are you? There you.
Yes, Ms. Munoz.
Who?
Ms. Munoz.
Say that 5 times fast.
Munoz. See if she did that. One tax. You got to hold top of them.
Is it Lyzette?
Just yes, we did last day.
Of course, the very last one in the big pile.
I'll over here. Don't worry.
The last shall be first. This is your time. 24 CR 2103 is called the state of Texas versus Lyzette Munos, who's present with Mr. Parker. your attorney and the state's attorney, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about August 4th, 2024 in Jefferson County, Texas, you committed the third-degree felony of engaging in organized criminal activity, which state that in summary, you collaborated in carrying on criminal activity intentionally and knowingly committing the offenses of theft on or about several days that are listed. And there's an agreement that's been reached where you would be pleading guilty to the lesser included class B theft.
Plus, I think it's plus.
It says class B.
Oh, and maybe it's the keys. That's right. That's right.
That's class. Yeah. I mean, I think that's
right.
a B,
It's a
but
B.
it's hard.
Sunny.
The pads look funny.
Yes, I've got it as a class B.
Okay. Which carries with it up to 6 months, up to 180 days in the county jail and or a fine of, help me on that one. $2,000, if we don't do that. Okay, this is. I gotta redo all of this because it's written out. So
So it should be in.
it's darn it. No, fit. Mary, Dan, come up for that.
I don't care, but yeah, you can.
What's the statute say? 180 days or 6 months? What's the statute say? On class B. I think it's 6 months.
That's right.
Yeah, you're correct.
Oh. They seem real confident over there.
The fine $2,000.
That's true. Yeah.
You understand the punishment range? There's an agreement that's been reached here that you would be pleading guilty and sentenced to deferred or unadjudicated probation, and that would be up to 2 years in length. And there is restitution, which is the key. You do that, you get shortened, you get rewarded for paying back restitution.
Paying that today, Judge.
Good, then it would be shortened, everything else in a third, everything else being the same, okay? And that's $3,796.39.
Right.
Okay. If I follow, I'm gonna put that. That's 7, this is 7. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Because
You want to speak up? How do you plead to this lesser included class B misdemeanor of theft, guilty or not guilty? Are you pleading guilty voluntarily, that is on your own free will and because you are guilty? Listen, I'm going to show you what's marked here, State's Exhibit 1. I'm going to ask, did you sign that, discuss it with your attorney, or the contents all true and correct? Yes, State's Exhibit 1 tendered into evidence without objection.
Objection.
Admitted. This states you are mentally competent to enter your guilty plea, which is freely and voluntarily. You know what you've been charged with? You guys, it's been read to you. You read it. You were guilty of the crime charged, and most importantly, in this disposition, any lesser included offenses, which includes this Class B reduction in as a lesser included offense of theft. You're giving up your rights to a jury trial and the rights to the appearance confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true and safe, so help you God under oath. Yes. Yes. You have self-defense. The court will, based upon those representations, make findings in support of those representations, that those are true and correct for the record. Pre-sentence report waived.
Wait,
I'm going to find if nothing further, you were pleading guilty today voluntarily. You're fully competent. It is, you understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am going to defer any findings of guilt and place you on deferred or unadjudicated probation for 2 years. You must pay restitution in the amount of $3,796.39. It's not listed. It just has the
Academy Sports and Outdoors, Judge. Yes, sir.
It is.
We just did the pleas on the others.
There's no, the only names are like co-defendants. So.
It's 100% Academy.
Okay, it goes to Academy Sports and Outdoors, 8453 Memorial Boulevard, Port Arthur, Texas.
we have the ultimate.
Okay, well, it has to be in the order. And if that's okay.
Yes, that's fine. Said restitution order, I mean, we got it.
No, it has to be listed.
Yeah.
So that there, if there's any civil relief that they use, they will refer to it and she gets credited for it. All right, the court has signed these orders. Please see the probation officer and you can begin. The quicker you begin, the quicker it ends.
I've been with the judge that we
Sorry,
want
we're gonna see at the end just because it's you.
Okay.
Yeah, well, who is it?
It's Sultan Barrera.
Okay.
We have an agreement. We just need to work out a couple of things. We could have a few weeks to put on the plea docket.
You got it, buddy.
Come on up.
Who is the defendant? Thank you.
Me just have him sign or you need help? Better sign?
Yes.
Okay.
On 16-26375, Kashan Washington. Kashan Washington.
Yeah.
Okay.
Again, Judge.
All right.
I think we need to pick back up on Mario Thompson.
Caleb Landry, what are we doing on Caleb?
The state is offered, well, state feel and both of the allegations, from everything, like sometimes I think about it.
That was 3 weeks. Where's Mr. Landry?
Landry was.
Come on up. You got 3 weeks resetting. Thank you.
Right, what was that for?
3 weeks resetting, sir. You get, and sir, how much time do you already have credit to use that you've served in this? Sure. She can look and tell you. You get credited for all of that.
Yeah.
Okay, Tiana Baker. Tiana Baker.
That was reset your eyes.
Didn't like that. Justin Woods. And Mr. Cheatham. Is your attorney here?
Yeah, he just came up here.
I think he might have gone across the way to.
Okay, hold on.
Court judge.
Till Mr. Cheatham gets back. Giles, Ashante Victor.
Yes, sir.
Ashante 23 CR 1799. Yeah. Looks like the one that's fixable.
Yes, sir. We've accepted the offer. I just need to get assigned to.
You okay. Oh, tell me, come on up in your crew. Let me know. Dwayne Francis, Don.
Judge, that's the person who's our, Paget, and we're waiting on Mr. Paget to get here.
Okay, where is he? Is he on his way or something?
Said he's trying to get.
Mr. Pageant's gonna be here shortly, I understand. Maybe. Reagan, what are we doing on Zachary Broussard?
He's a plea judge. His paperwork is one.
Thank you.
I think you might have it, Judge, on Zachary Bruce.
Not yet.
He's next. I'm working on it.
Javon Narciss?
He was Judge. He's done. Yeah, we already took care of that.
That's fine. Okay, Mario Thompson.
Yes, Judge.
I'm skipping that one because it's you.
Thank you.
Okay, come on,
we're just-
is that Mr. Thompson?
Yes, this is the question. And I spoke with the prosecution.
How's that going?
We got
They're speaking to
Sarah is speaking to me.
That's a good thing.
My schedule and due to try to get things set up for work. I had a 60-day reset.
Is that long?
And it would play that day.
Should we do 6 weeks?
Yeah, I'm just gonna get it
6 weeks.
July 25th. Is that possible, Judge?
Let's see, today's about June.
Yeah, today's May 29th.
8 weeks?
No,
What you want, you're asking, okay. And then we'll dispose of it then?
Thank you.
Thank you. Okay, get a reset. Thank you.
After July 29th.
Yeah, the first date after that. Okay, thank you.
You are Thompson.
Hey, guys.
Thompson.
Yes.
He's right there. Sure.
24 CR 246. This one is, this is fixable.
We're just getting discoveries today on it. They had to be through.
How much time do you need? 4 weeks?
Or 6 weeks.
That's 5 weeks.
I'll be in trial between now and the end of June every week.
Really? Where at?
Yeah.
Oh, different courts?
Can you conduct one more time?
Like I said, we're getting case in process on speed. We can have a trial.
Okay, so when can we?
And so we set us out for the banks. So if he's 18.
That's a.
Yes, sir. So-
Get it quick. If it's gonna get disposed of, probation thing.
Yeah, I'm signing for the discovery. Good looking at the videos. I'll talk.
I don't know what is, it's not showing.
It's not discovery history. Judge.
He doesn't.
Oh, kids out shooting rather than out in the country.
Oh, this is fictional, maybe.
I think so.
We'll see.
I think that's that, yeah.
So if I can get 6 weeks, that gets me out.
You got
of trial
it.
season.
6 weeks, reset. Okay, so get resetting.
How long?
Here, 6 weeks between 5 and 7.
That's our.
LaDonna Lewis.
Yes, Judge, we got that. Sonny got me the rest of the last day of the ceremony.
They've been waiting on me for some information, Judge. I just got it to them today, so they're gonna be fine.
Okay, LaDonna, get 6 weeks resetting here. Sounds like they're working on getting that done. Colton Barrera, I think we,
You moved that one,
already.
Mr. Parker's request.
Jason Noble.
Lori?
Yeah.
Jason Level.
Let's just do the. What do you say?
Here's that.
Well, we like said, we want to offer this position.
Hold on. Do you have any more files?
I didn't.
Maybe you.
Hello.
They're just
Yeah.
large.
What's this? Oh, this is the pre-sentence report.
Yes.
Okay, so no.
Missing a supplemental report. I'm missing the supplemental report. I understand that the officer spoke with the complaining victim and the wife, the complaining victim. And
Well, this is here. This is the supplemental report. 1 sentence long.
okay.
Do you want to call Mr. Cheadle, the guy from Houston, while they're looking over that?
1 sentence. Ready?
Ready.
All right. What do we call? Jason Noble,
Agent Dusty, Judge.
we'll need Jason Noble. Killings.
Your Honor, if I'm, since my client hasn't seen that, can I have that back one more time so we can take a look at it?
Yeah, y'all just sit right over there and then let me take Stephen Dodd.
So make sure he sees it.
Okay.
Morning, Judge.
Yes, sir. How are you?
I'm doing fine.
A good trip today?
Yes, I did.
You didn't walk, I
No,
heard.
sir.
Mr. Noble, right over there in the top. Stephen Dodd, come on up, Mr. Dodd. And this one's fixable too. This shouldn't be a big deal.
No, it's not, Your Honor. I just, I've got the paper discovery. I don't have the.
How much time do you need?
I mean, 6 weeks or so.
Yeah, 5. Can you do 5?
Yes, yes.
All right, we said 5 weeks and just follow the advice of this good lawyer, okay? Thank you. Get a reset,
Thanks,
sir.
Judge.
Thank you. Good to see you, sir.
Thank you.
Good to see you, Mike.
You too.
Christopher Alvarado, John?
I'm just going to reset.
That's a big,
Just that, it should be on the side. I've seen it, yes, I saw that.
okay. Hey, more than one place, so let's, 2 cases here. Did he plead the both?
Yeah, just one judge, the other, well, we get involved, that's gonna be played.
He's gonna be dismissed today.
Yes, sir.
Okay.
I believe I signed it at the time of the plea, but you should have the dismissal with.
So I gotta go back in time, right? Then
Something you're very good at.
and let's see.
Yes,
Yeah. I don't see. I don't think I need the plea though. You're right. I don't need the.
You shouldn't.
Plea shakers. All right, we call 2 cases, cause numbers 25 CR 59 and cause number 25 CR 60, the state of Texas versus Christopher Alvarado, charged with aggravated assault with a deadly weapon in 5-9 and deadly conduct, discharge of a firearm in 6-0. I have documents on 5-9 for 5-9 deferred adjudication documents. And for 17, that's just when this hearing occurred. But I'm not showing this. It's not. The next, I've got a 527 and then it goes to 331. I don't have anything on 417. I don't think I need it.
Judge, got them in my retrieve. Let me send it to you. Okay, you should have now under 417. It's the same. I don't know, because we're just a temp this one.
Okay, done. And earlier on April 17th of this year, the defendant entered plea of guilty to aggravated assault with a deadly weapon in cause number 25 CR59. And the pre-sentence report has been prepared. And the agreement is whatever sentence shall not exceed a cap of 10 years in prison. So I think we're looking at no less than 2, no more than 10 years confinement in prison. Also deferred or unadjudicated probation is an option, and regular probation would not be, since firearm was used in the commission of this offense. So the parties had an opportunity to review this pre-sentence report prepared by the probation office. Any corrections or changes to it?
Not from the defense, Your Honor.
No. Then it's made a part of the record for all purposes. All right, go ahead.
Your Honor, I think, first of all, I'll get the big thing out of the way. Okay, I think, we have to start with that. But a couple things I want to point out, and we're going to be asking for probation, and here's why. Number one, this is a case where it was not intentionally or knowingly. I think it's a general practice thing. We didn't intentionally try to hurt anyone. It was being an idiot or whatever you want to call it, on New Year's Eve, firing a gun, and one of the bullets struck a child. Okay, it wasn't like he was pointing at anybody or trying to shoot at anyone. Doesn't make it. I mean, it does make it better in a way, but it's still a bad situation. He's been remorseful about it. He has been taking responsibility for it. He's even in the PSI admitted I shot a kid. It wasn't, again, I just want to make sure the court understands it's not like he was pointing the gun at them and trying to hit somebody. He was completely being reckless, which led to this. Another thing, Your Honor, is that there's, even though the PSI didn't give the amount of restitution, I'm sure it will be restitution. The kid did go to a hospital and has had medical treatment. So there's restitution. This is something the court deferred probation, make him pay restitution back. He can't change what he did, but he can help the family make the right as far as financially. I know they would rather the kid get not shot at all. I think everybody would agree to that, but so and even the PSI, he has no criminal record. This is his first time to be in trouble. He has admitted the guilt. He's admitted that he did something wrong. So we're asking the court to consider giving probation, in this case, deferred probation. And I say deferred because I don't think he can't get regular probation. And if he could get regular probation, we do ask him for regular probation. But deferred is a possibility. And tries to make it right as much as he can. Like I said, we can't go back in time to fix what happened, but he can try to make it amends somehow.
Stay.
That's been the argument throughout the manner of this case. Mr. Weston and I have gone back and forth about Mr. Alvarado's conduct. The end result is his conduct caused unnecessary injuries to a child, and John knows. That's why it starts out with that argument. But I want to highlight a couple of things. First off, what's not detailed in the facts here is that when we get into the exact details of this particular evening, Mr. Alvarado went to his friend's house solely for the purposes of drinking and shooting fireworks. That's what all the witnesses told the officers that night on New Year's Eve. I mean, so he starts out admitting that what he's going to do is criminal conduct from the onset, as compared to one of his friends who took a shotgun and was shooting into the ground. Mr. Alvarado chooses to level his gun and shoot through a fence where this child was living next door and was shot, injured, specifically suffering 4 different gunshot wounds on this 3-year-old. I cannot in good conscience agree to give this man probation under those facts. I will say to his credit, he did step forward that night. He has never been in trouble before, as Mr. West argues. But it's just hard to step around that type of conduct. The other thing that speaks against Mr. Alvarado is when we look at, what is his conduct after this incident? And I'll point to the court his substance abuse history. Had I been in that scenario where I was drinking and doing what he did, I would have stopped the conduct that's noted under page 2. He kept drinking and telling the probation office that his last use was Sunday. He kept using drugs, detailing that conduct there too. So when you argue that he's remorseful about it, maybe by his words, but not by his conduct. Judge, if you're considering giving this man a deferred probation, which is our only option because straight's not available, I would ask that you give him 180 days upfront state jail time, not something that's done on weekends, because we need to make sure that we've got his attention about what took place here.
Anything else?
No, sir.
Did you want to say anything, sir? This is your time. Go ahead, Mr. Alvarado.
If he can give me a chance, I mean, as he said, I wasn't drinking the night or smoking or using any type of drugs. But if you please give me a chance, like they said, I don't have a criminal record or anything like that. It's me being stupid or whatever you can say, hanging out with the wrong crowd of people. I just ask you to give me a chance, give me like preferred probation. Because I'm extremely apologetic to the family and, dad that I shot. I didn't have any intentions of shooting anybody. It's just me just being reckless. And if I'm in your heart, just go that for probation.
Is there restitution here?
There is restitution, Judge. It's an unknown amount. I've had contact with the family, and I don't think they understand the detail of what restitution involves. Their comment was they didn't have the amount of out-of-pocket expenses.
Okay.
Meaning that there's been insurance that's covered as well. So if we head that route, there will need to be a separate restitution here.
Anything else?
I just want to reiterate some of the stuff they said. Like Mr. Ham said, this is my client's position from the beginning. It's not like he denied it from the start. So I had to do it now. So okay, now I'm caught. I'm done, which we see quite often in here. He's from the beginning. It's like, I'm sorry I did this. He's always been apologetic from the start of this. As far as any kind of drug or alcohol use, that may be something we need to address in probation. That may be something that's a problem. I don't know if it's contributed to this or not. May have, may not have, I don't know. But it's just one of the situations that I think that if this was an intentional act, I would not be making any of these arguments. But in fact, this is a reckless act. This is not an intentional act. And I don't think even the state is arguing that it's intentional. Not intentionally shot the gun, but I don't think intentionally meant to shoot at anyone. I don't think he knew anybody was on that other side over there. So we're just asking to give him a chance and put him on probation. If he steps out of line, then he'll be right back in front of you and off to prison. But if he's successful and includes probation, does what he's supposed to do, which most people that get put on probation are supposed to do succeed, then society's better off. Also, you get the chance to pay the restitution. We don't know what money it is, but it's something. There's some money's owed somewhere, and that's what we're asking for now.
All right. It needs to be understood. Then it can't be downplayed that recklessness when you're dealing with a firearm is just as lethal as intentional. And the statute provides for the same punishment range for intentional, knowing, or recklessly doing something. So recklessly, you can say it's not intentional, but the law provides the same punishment. The harm is the same. If someone is shot, whether you're acting recklessly or intentional or knowing. So. And at the beginning, the defendant was stating it was an accident, which is not the test. And I know people misconstrue and confuse recklessness with accidental.
Yes.
But recklessness has a definition under the law. And somebody who acts recklessly, like you admitted to, is responsible for the harm they cause. Because it says that you're capable of understanding and appreciating the harm that can be caused. Here's a child, was 3 years old?
Yes, sir.
If that child would have been killed, that'd been capital murder. You'd be looking at the death penalty. That's how close the catastrophe was. Apparently, even though it was a 3-year-old child, the wounds were not, it did not end up being severe, which is a miraculous event. It was a miraculous event.
Yes, sir.
It had nothing to do with you. It was God's will decided that that child was not going to be taken to heaven at that time. But it wasn't because of foolishness that you and the others pulled it. Shooting into the air. On New Year's Eve, shooting into the air. It's like you don't know. You think the bullet's going to dissolve before it hits the ground or hit somebody. It doesn't. It's going to fall and it's going to hit somebody, whether it's shot up in the air or laterally. Here, the child was shot in the feet, in the legs, lower extremity. Lucky for everybody. All right. The court is going to make the following findings that the defendant has pleaded guilty to this serious second-degree felony and has admitted to acting reckless in his actions, and he has pleaded guilty voluntarily, knowingly, intelligently to recklessly causing this assault with a deadly weapon. And there is sufficient evidence supporting his guilty plea from State's Exhibit 1 to find him guilty beyond a reasonable doubt. This court is going to find that a finding of guilt is going to be deferred at this time. He will be placed on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation which are reasonable and normal for this type of offense. And these will be reviewed with you. Restitution is to be ordered in an amount that will be determined and it's agreed by the parties that restitution is likely that it hadn't been paid by an insurance company. But then again, if they had insurance pays, then they're hurt. So I don't want them to be harmed in any way by your foolish actions. So you're going to pay restitution, even if unless the insurance insists they're paying, and that the victims, the person who owns the insurance, are not going to be subject to additional higher premiums. But you're going to pay whatever it is determined that needs to be paid, that's being absorbed as a cost to the victim, the child's family. There will be other terms and conditions. This will be for 10 years. You will be placed on deferred or unadjudicated probation. Also, we all are talking about how serious this is, and it would be it would not be just if the court did not order jail time as a condition of probation, which is representative of the harm that was capable of being caused by your foolish, reckless actions. You must serve 180 days in the county jail. And I'm going to give you the option. You can do 180 days straight, or you can do it on weekends if you wish, because I've opened the door for that. And you can continue to be employed if you're able to. And if you work Monday through Friday, then you would report on or before 6 o'clock p.m. each Friday. The thing is on that is that's 90 weekends in a row. People find that is excruciating.
Yes,
That doesn't bother me. It's your choice. You can either do straight or you can do 90 successive weekends.
PSI reflects he's unemployed, Judge.
Are you working somewhere now?
Yeah,
Where?
Wednesdays.
Okay. Do you work Monday through Friday?
You know, it's I mean, I'm off 2 days.
Which 2 days? Are they
It
different?
depends on the schedule.
They change their schedule.
Well, you got to make a decision right now. You know, you're going to have to do, it doesn't have to be weekends. It can be 2 days for every week, but it's going to be 90 weeks or
So as long as
6 months,
as long as he does 2 days a week, doesn't matter.
successive days. Yeah.
You have 2 days off every week, right? Yes.
And you're gonna have to work that off with the probation office so they know. And you're gonna report on or before 6 o'clock p.m. You will stay for 2 nights. And then they will release you 6 o'clock the following day, the 2 days later. But I did that because the report I get is excruciating for people to leave it and know they have to come back in a week and over again. But if that's what keeps your job, then that's what we're gonna do.
Need a,
I should have gotten it when people in it.
that's right, you do.
Beyond your worry, yes, the other who's on topic or the law, they normally don't. Just. Wishes and they show out.
Well, it's up to the judge, it's all up to the judge, because we didn't say it, so.
You got to work with the probation officer so she knows when you're going to be reporting so that we can follow you along. Set out this one. You want me to sign this? Which one? This one that you just gave me? Mhm. Okay, if I do let you know. Thank you. You understand what's happened today, sir?
Yes, sir.
Okay, see the probation officer immediately. I think another case is to be dismissed, correct?
Yes.
On, under that same days.
No.
No, only me, I don't think you did, that's right.
Oh. Is Mary here? Battery is low.
Judge, we'll just have to switch
Just what
on
we
the
need.
tablet. She want that storage now. It went back upstairs with one of the tablets. Judge, can you hand me that tablet? I'll switch it out with one that's got a battery. Yeah, would you grab me a tablet that you have that's charged up? Okay, that works.
Giles, you have something?
Yes, sir. We're ready.
Come on up.
Have one.
What do you have?
Have Damien Walsh.
What are we doing?
We're gonna reset that. We had a bargain on the table, maybe take that, but we want some time, whatever. So if we can get about 34 weeks.
On up. Waltz. How much time?
About 34 weeks.
24 CR 2343, reset 4 weeks. Come on up. Thank you. Here.
This is the walls.
Yeah.
Damien, it's 2 cases or 3?
Should be 3.
I've got 3 cases on him. Thank you. All 3 cases are reset in 4 weeks.
On the highlighted X for me.
Giles, your client is who?
I don't partner in one with Judge. Right here.
Victor, is that who's?
Judge. This is not really this.
Right.
Yeah, I didn't. St. John's, that's why I.
That's right there. Just give me a minute, let me get the tablet.
I don't know what I would promise, but.
Oh, what are we, having to redo something?
Yes, sir.
Okay.
And you got that one, yeah.
Should be. Maybe an add-on. Oh, yeah, I don't.
That's from yesterday, Judge. You might have the file. Look, I'm working on it.
No. No.
Let me go look at see if it's on my desk. He was a no-show yesterday, Judge. Hold on.
Where is he?
He's here. Right.
Well, I don't have a file yet. Hold on. Let me get somebody, let me go on something that we can do.
Judge, I have already, it should be ready.
Ma'am,
B.
who is it?
Zachary Broussard.
Is that your last one?
Yes, Judge.
Let me take that one and get down to. Is it 2 cases?
Yes, Judge, one of them is being dismissed.
All right, Zachary Broussard, come forward.
How about right now? Yeah, exactly.
That's you, Zachary Broussard? It's in 2 cases. 23 CR 1815 and 24 CR 1945, Paul. And these are state jail felonies, theft of a firearm and unauthorized use of a motor vehicle. On Zachary Broussard, is he signed up?
He is signed up. I'm getting you a towel. He's playing on the theft of the firearm, and then for the plea, we're dismissing the UUMV.
All right, so 1945 is to be dismissed. Let's look at 1815. Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, Judge.
In summary, the defendant who is here with Ms. Minaldi, her attorney and the state's attorney. The defendant is charged with on or about August 14th, 2023 in Jefferson County, Texas, committing a state jail felony of theft of a firearm. Do you understand what you're charged with?
Yes, sir.
If convicted, you face no less than 180 days up to 2 years in the state jail, and a fine of $10,000 can be assessed. Do you understand? An agreement's been reached. What is it?
Deferred.
All right. The defendant would be pleading guilty, placed on deferred or unadjudicated probation for 5 years and fined $1,000. Is that? Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case, do you understand? How do you plead to this guilty or not guilty? I'm sorry. Are you pleading guilty voluntarily? That is on your free will and because you are guilty? Yes? You have to speak up so this. All right, I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tender?
No objection.
Without objection, admitted. This states you were mentally competent to enter your guilty plea freely and voluntarily. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to your jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation you provided your lawyer. All true, so help you guys. State's Exhibit 1 made a part of the record for all purposes. And the court makes findings in conjunction with that State's Exhibit 1 that those admissions are all true and correct, and the court finds that to be true and correct.
Yes.
Based upon the sworn documentation by the defendant. Presented before his way.
Yes, Judge.
I'm going to follow this agreement and find you're pleading guilty voluntarily. You're mentally competent to do so. There's sufficient evidence supporting your guilty plea from State's Exhibit admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation which are normal and customary for this type of offense. You shall be ordered to pay a fine of $1,000. You're going to have to complete satisfactorily the theft prevention class that everyone takes for this type of crime. There will be other terms and conditions of probation, normal and customary. Make sure you follow them. If you fail, probation could be revoked. You could then be found guilty and sentenced up to 2 years in state jail. We don't want that, do we? Okay, so please see the probation officer and you can begin probation.
Thank you.
And there's a companion case, 1945, that is a motion to dismiss before the court, which the court is signing. You know, this pad works like a Ferrari. Why don't I have one of these? This thing smooth as silk.
I know, because yours just like that, the battery
Bad one.
is bad.
Yeah,
So
the
we're
bad
getting a new tablet. I hope it's,
Yeah.
I just, can't get it over.
Who's next? Who do we have?
Take that file, maybe.
What are we doing?
Mr. Cook, Richard Cook, you're
Gotcha.
still going through discovery. It's a new case, so.
He was on
Where is it?
retreat yesterday.
Oh, he's bond forfeiture?
Well,
He was originally scheduled for today. My office actually asked to move him.
Okay. Did we fix all of that from yesterday, or was there a warrant issued for him?
I do not believe the warrant was
Okay.
officially issued.
So what do you,
One more announcement, we'll have the case ready to be resolved.
okay, 4 weeks, you got it. Get a resetting. Thank you.
Just quick approach on Justin Woods. We, this is unlawful. carry,
Where's he?
And he's.
Come on out.
This is the first setting I have been into. I apologize for being late.
It's one case, right?
Yes,
24
yes.
CO,
I spoke to,
third degree felony, unlawful possession of the firearms by felon.
Yes,
Yeah,
Judge.
and Mr. Chica. Yeah.
Yes, yes.
So what are we gonna do today?
Today, we're asking for a reset just to, we're.
4 weeks good for you?
Discovery, 4 weeks,
Done.
great.
Okay, get a reset.
Thank you, Judge.
You bet. Well, yes. Come Jason. No.
And Your Honor, I have one witness besides Mr. Noble that's here. Okay. That's present. Sorry, there, right? And here is that.
Right, what do you think?
Judge Washington, Your Honor, Mr. Garfield.
In Sharpie hearing.
Last time.
Oh,
Yeah. He's,
okay, this is the supplemental.
Here's my motion.
This would be the line.
Not the right motion.
First
It's
one,
a,
five.
you can't do it.
Your Honor, I see that Mr. Nichols' remaining case, the scholarship case, is on the same docket. And it says sentencing, but I don't think that's correct.
Just all follow
Because
It just-
he didn't.
How can there be a sentencing when he didn't
Well, I don't
leave? Well, it's obvious a mistake.
No, I just
Follow each other, or who only said it in one.
Okay, and I just wanted to
Yeah,
make
so
sure
that's-
that.
Well, that's gonna be dismissed, right? Is that what it's? Oh,
No,
that's
sir.
right. Okay, so this is, clause number 39549,
Yes.
this one.
Yes.
And then there's still 37734.
Yes.
All right, it's called State of Texas versus Jason Gregory Noble.
Your Honor, should I bring everything?
Here represented by his attorney and the state's attorney, Mr. Rosa is representing that defendant. And the state's attorney is present. Mr. Noble earlier is.
I'll do plea or disposition.
Have you already entered a plea?
Jury trial,
Oh,
Bill.
jury.
He opted for you to determine sentencing. If I remember correctly, Judge, there was a plea true as to the
Follow up with an email.
virus. So his exposure is 25 to life.
It was a second degree felony just on paragraph 1.
Yes, sir.
And then he pleaded true to paragraphs 2 and 3. What's that make it a habitual felony?
Yes, sir.
Okay, 25 on.
Yes, sir.
All right. Pre-sentence report has been tendered to the parties. Any objections or changes to it from the defense
Mayor.
or state?
No, sir.
Okay. The agreement is, again, the courts, it's open to the court for sentencing under the punishment range that is applicable under these circumstances. So what says the defense?
Your Honor, I would ask the court to take into consideration that although there is an extensive history of assaultive type cases and offenses involving violence, I would ask the court to take into consideration that Mr. Noble was introduced to violence at a very young age, 13 years old to be exact, by his father, when he was at a critical developmental age in his life, and began with assaultive offenses as a juvenile, as young as the 11th grade. And it's kind of continued on since then. And Mr. Noble has not received any kind of treatment for his anger and his aggression ever. And
How old is he now? How old is he?
51. He's 51.
Whose fault is that?
No, I'm not saying that it's anybody's fault.
Oh,
I'm just
okay.
pointing
Well,
out
we
the
wanna know
fact that he has not received any kind of psychiatric treatment or counseling or any help to manage his anger issues.
So it's nobody else's fault.
Yes, sir. And on top of that, he also has been diagnosed as being bipolar. And he admits that he was prescribed medication, but he stopped the medication. And I would like to point out that there's never been any kind of medication management or oversight, and that may have contributed to some of the anger issues and his overreaction in the present case.
You're cryptic. What does that mean?
Which part?
There's no oversight, and what does that mean?
Well, meaning that he didn't have any help with.
When you prescribe medicine, when you're at home, you take medicine as prescribed. We all do. The doctor doesn't come in and says, okay, I'm going to watch you in video to make sure you do it. We're grown-ups. You're prescribed medicine. You can either take it or not take it. It's free will.
Sure.
And if you don't, then if something bad happens because of that, then whose fault is it?
Well, Your Honor, I'd like to point out, in Officer Riley's report, that because he was not receiving mental health treatment and going to regular counseling sessions and getting, that they could not ensure that he was receiving this medication.
Why not?
Well, because it's just never been ordered in any of the times that he's ever been on probation.
Hold on. He's not going to regularly schedule doctor appointments? That's what you just said. Whose fault is that? Okay. Well, who ordered the treatment?
Well,
Was it recommended by a doctor? But you didn't go.
I was traveling in town.
What, that's your, whose fault? Okay.
okay. There's also been an extensive problem, extensive history with substance abuse. And I'd like to point out that Mr. Noble has never received any kind of treatment or rehabilitation or therapy relating to his substance abuse issues. He did report that he was going randomly to NA and AA, but the last one was in 2018. So taking all of these things into consideration, I would ask the court when it discusses the sentence that it show leniency. Mr. Noble, on the date of this offense or the date that this offense occurred, he truly believed that what he did by trying to disarm Mr. Knighton with the weapon, that he was saving his life and his mother's life. Based on the fact that, according to Mr. Noble, as it came out in court during the trial, Mr. Knighton had discharged the gun prior to that evening when he was high on methamphetamine. Or methamphetamine. And so, Your Honor, even though he did overreact, the injuries were severe, but he truly thought that he was doing what was necessary to get the gun away from Mr. Knighton. And in the supplemental PSI report, Mr. Knighton himself states that he has forgiven Mr. Noble, that he actually resided with him when he was out on bond after the current offense. They've set aside their differences. They call each other, or Mr. Knighton and his mother have continuously contacted him and spoken to him on a regular basis. And although they did not appear, and I'm not making excuses for them, but they really did not want this case to go forward. And unfortunately,
Why do you think?
Well, because he didn't think that he should serve any more time, that he's already served time, and that's according to what's in the PSI report. It's time served. That's what it should be. So the victim himself is telling the court and everybody that he comes into contact with, in addition to signing 2 non-prosecution affidavits, which, you know, never came out because he didn't appear. He didn't appear in court. He has consistently held the position that he did not want Mr. Noble to be punished for this. And why would a person do that? It's not because he was scared of him.
I'm sorry, the victim, as we recall,
Yes.
had the gun, the barrel of the gun imprinted on his forehead.
That is correct, Your Honor. I mean,
Gee.
and I'm not
Well, what do
downplaying
you-
the injuries.
What do you think could be reasons? Maybe a victim like that. This court has never seen such a thing. Never seen somebody had to jam a hot metal. The gun had been fired in just a few seconds, stuck up against the forehead and burned into the man's forehead. The barrel of the firearm. How ruthless is such a thing? How ruthless. They had to think the next moment, the trigger will be pulled and there's no escaping it. A bullet goes through your brain.
Well, Your Honor, I'd like to point out that at the time that the gun was used to hit Mr. Knight in the forehead, the chamber or the magazine had already been expelled and the bullet in the chamber had been ejected. And that's according to his own testimony, and it was found in his pocket. Mr. Knight.
So play down the fact that he puts a burning hot piece of metal in the man's forehead. Play that down, would you please? That is as mean-spirited as it gets. What? Okay. Oh, so was he doing it for fun? No, he was doing it to hurt the man. It was just an act of meanness.
Your Honor,
You were-
can I call Mr. Noble? He would like to address the court, if you would give him the opportunity.
Yeah. That's you?
Yes, sir.
Raise your right hand. You solemnly swear or affirm testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Lower your weapons. Go ahead.
And I would like to apologize, Judge Stevenson, for wasting your time, that works time. I did not want to go to trial in this case. I was in Mr. Anders made an offer to me. My stepfather, he comes to see me regular up here in Jefferson County in their 2 years. And I told them that the offer was 20 years. And they told me, do not sign for 20 years. If you have legislative leave, the offer was for 20. We have forgiven each other about the altercation. But if it was a saying just a few seconds ago about the pistol thing, my stepdad did fire a firearm previously about 2 weeks prior to this inside the house. And it really scared me, scared my mother. And there's a lot of other episodes.
So it's his fault?
No, sir, it's not his
The
fault.
jury found otherwise, you know that.
Yes, sir. I'm going to respect the jury's decision too.
All right. Let's respect the jury's decision, finding you guilty of aggravated assault, family violence.
Yes, sir. And there's no excuse for me acting like that, behavior like that. There's not understand that. But I guess I overreacted in the heat of the moment.
Which time?
What happened?
What about your prior convictions, which are crimes of violence? Let's see, arson?
Yes, sir.
And what, after that, aggravated assault, another aggravated assault. You were convicted of that in 2010. How many violent crimes do you get before you're held accountable? And I'm looking at your criminal history. How many convictions do you have?
She said I had several misdemeanors.
No, no one should know more intimately about their actions than themselves. How many convictions do you have?
Now 3 felonies, convictions on like she's 20 or 30 misdemeanors.
You see anything wrong about that?
Yes, sir, very wrong. Very, very.
After all of those, now you're here before the court for another crime of violence. After 20 some odd convictions. We all see a consistency that should have been dealt with 25 convictions ago. You should have learned a lesson. Okay.
I'd like to call Philip Jones, who is childhood friend and boss / coworker of Mr. Noble.
Come on in. Come on in. Where that person is, that's who that is.
Yes.
Okay, what is your full name, sir?
Yes, Philip James Jones.
Raise your right hand. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Lower up.
Yeah,
No, this question and answer. Go ahead.
Mr. Jones, your name is Philip Jones, is that correct?
yes, ma'am.
And how long have you known Mr. Noble?
Since he was probably 12, 13 years old.
And
How long?
12 years old.
Yes.
since Mr. Noble was
I'm a
12 years
little,
old?
yeah, I'm a little older than him.
Your childhood friends? And, did Mr. Noble work for you at one point in time?
Yes, ma'am.
And what did he do?
He was a foreman, supervisor,
And what type of job was this?
scouting.
Okay. Now, did you ever witness any violence in Mr. Noble's household when he was younger?
Yes.
Could you describe that?
Well, I can tell you, like, when we were kids, we were going to fight it out. We'd go to fight it out in the backyard. And if we did something wrong, we would get a whipping. When he was a kid, he would get beat up by his dad, with his fists. And, so.
Okay,
Oh, well.
be there. When you say he was beaten up by his dad with his fists, can you be a little more specific? Like where his dad punched Mr. Noble?
Yeah, his dad would, he would just basically take him and beat him, punching with his fists in the face, in the back, wherever he turned. And then he would get away and never goes and we could like.
Okay, now, Mr. Noble's father committed suicide when his father was 45 years old, is that right?
Right.
And how old would Mr. Noble have been?
He was probably, well, he was in prison when that happened.
Okay, so he was an adult.
He was an adult, yes.
Okay.
27.
Correct.
Thank you. Okay.
No, so wait, hold on. Your father died at 2001 at the age of 45 by suicide. So at this stage, I'm sorry, you were born in 74. So that's 27 years. I should know more about this than you do. Go ahead.
Is there anything that you would like the court to know? Well, let me ask you this. Did you ever know Mr. Knighton, the complaining victim in this case, to use drugs?
Yes.
And how do you know that he used drugs?
I know that he used drugs. He had my nephew and his Jason's son do up drugs when they was a kid. And so that's back when Logan and Caleb were young. Logan got into some trouble with Kim, and they were shooting up. He was shooting them up with cocaine, not cocaine. I think it was crystal meth at the time.
How do you know that?
I don't know that. Logan is my nephew.
Okay, and
Logan's mother is the one, that actually that made them get away from there because of what was happening with them doing drugs at Jason's mom's house.
Well, what did the adults do about telling the authorities so that someone could be held responsible?
No,
you don't really know. You were a kid.
Well, no, I wasn't a kid. Logan is my nephew. This Logan is.
I'm talking about when you were watching him.
No, he was in prison when this happened.
Okay.
When Kim was doing drugs with Jason's son.
Okay, so what adult figure needed to talk to authorities to, that's a
That would
crime.
have been Logan. That would have been Logan's mother. Yes, sir.
But other people knew about it, right?
Yes, a lot of people knew about it.
But nobody.
I don't know that they filed any charges on him for that. No, I do not.
Now, the night of the incident, were you contacted by,
Jason's mother.
and Jason's mother is,
Yeah. That's his mom.
okay, and Mrs. Knight.
Yeah, that's Mrs. Knight. Mrs. Yeah, I know her first name. Miss Noel.
She had your phone number
Yes,
and she contacted you.
right.
And what was she wanting you to come over for?
She was wanting me to come over to calm Jason down
Okay, go ahead.
because Kim had fired off a gun and then Jason tried to take it from her and hit him with the gun and but
So did she tell you that, Kim had fired a gun? And that Jason,
Objection, that's hearsay response.
Sustained.
President Simpson impression exception, Your Honor.
Overruled, overruled. It's hearsay. There's no way this, this can be tested by cross-examination.
Your Honor, if
I
I
made
may,
my ruling. Thank you. Move on.
no further questions, I'll pass the witness.
Thank you, Stan.
I have no question to this witness.
If you wanted to add, sir?
yes, sir.
Go ahead.
I've known Jason all his life. He has, had a little rough life. He's always done anything for me and he's always, and the whole time that I've known him, he'd give me a shirt off his back. He'd give any one of his friends a shirt off his back and he would protect you like you were his father. If you would, just like he would have protected his mom that night, he would protect you. I can tell you, he stayed with me for almost a year and a half after he got out when I bonded him out. My grandkids love him. They miss him to this day. He's a good person. He needs some help with his anger issues. He's never gotten to deal with that. But I can tell you, he's a good person. He don't deserve to go through the rest of his life.
Wouldn't you agree that a person really is judged by the decisions they make?
Yes, sir. And I can tell you, my mom was murdered by her husband, beaten to death. And I wish I'd have been there today to take that from him and kill him instead of him killing him.
Oh, I understand. Self-defense is
Yeah.
under the law.
So you have to.
But
also
the defendant,
take into
I'm looking at, the defendant has been convicted. He's been convicted of arson and was sentenced to 20 years in prison for arson. An aggravated assault, sent to 8 years in prison in that case. That was before this one. All right. Then we're talking about, he was convicted of terroristic threat, harassment, family harassment, convicted in misdemeanor court, sentenced to jail and those, assault, family violence, assault, terroristic threat, assault, family violence. All those were convictions. Don't you think that this is a consistency of bad choices? We're talking about violence, crimes of violence. How many mistakes do you get to make before you realize, this isn't the right choice to make?
I
It's a tough.
I totally understand that.
I know.
And I know about a lot of those cases, especially the one with Carl Kruger that.
I don't know. I don't know who people are involved in this. I'm just looking at his convictions and stretch back to 1992.
And what I'm asking, can you give him a little help?
Well, first of all, the help needs to begin with the person who's been making a mistake for 33 years. 33 years as an adult. I mean, it's like you and I, we're all judged by the choices we make. And when we put our hand on the stove, it burns us. We go, well, we're not going to do that again.
Well, I'm not asking you to make him a better person. I'm asking you to give him a chance to put him in a type of program that can get him to a better person instead of going to.
What are you suggesting is going to change his demeanor?
What I'm suggesting is going to.
What do you suggest?
I suggest counseling with.
What kind of counseling?
mental counseling.
What is wrong with him that you are aware of medically?
Yeah. What am I aware of is medically that he don't take his bipolar medicine. The only reason he couldn't take it whenever he was at my house because he was in between jobs and then so I can tell you as a standpoint, if you don't have the money, how can you take the medicine? You know what I mean? And then if you go in and off on that's a whole other way out of my belief. But I can tell you that working through your mental problems with some type of counseling is better than going and fighting.
I understand, sir. I understand,
You know what I mean?
but I don't know why things weren't done 33 years ago. And here we are.
I can attest to that.
Here we are, and we're cleaning up messes from 33 years ago that adults should have handled a long time, responsible. Oh, I don't know. It's frustrating for us all.
Yes, I mean, especially when you love them first.
All right. Is this man really excused? Is this man excused?
Yes.
Okay, thank you, sir.
Thank you.
Who's next? Who's next?
That is all I want.
Okay. Go ahead. Estate, did you have anything you want to add? What's everybody arguing for here on?
25 years.
Go ahead. Is there anything else you want to add?
No, you're wrong.
Judge, I appreciate Mr. Noble's friend showing up and speaking for him. However, the truth is that he was interviewed by law enforcement, never offered any of the comments that he made today about who said what, when, and where. All that's just another great example about how Mr. Noble has done everything he can to try to manipulate the system. Let's start with his victim in this case. He did come to my office and he did give me a affidavit of non-prosecution.
You're talking about?
I'm talking about Mr. Knighton. And that, as is my practice, whenever someone comes to the office with an attempt to try to drop charges, I visit with them. And one of the first things that I ask him is, did these accusations occur? That's routinely what I do every time. And Mr. Knighton said, yes, it happened. I have to have some peace at home. The only reason why I'm doing this is because my wife's making me do it.
Jack to the hearsay, Your Honor.
Okay, sustain.
So the reality is, after his state confirmed that the accusations were true from Mr. Knighton, so that's why I proceeded forward. He was represented by different counsel. They went through other efforts. They actually brought Mr. Knighton in. They got him to do a different affidavit saying that those things didn't occur. But the facts are what the facts are, and that's what was presented to the jury. These arguments that he makes today about trying to disarm them and discharging them, that he allegedly overreacted, all those arguments were presented to a jury and were found lacking. They found him guilty. And what we see here today is just another situation where Mr. Noble does not accept responsibility for his conduct. Even his counsel's argument starts out blaming his father, which you heard from Mr. Jones, about his upbringing, that he's never had any treatment, that he's made his own decisions about whether or not he's going to take his medication. The reality is that he committed this offense, Your Honor. I'm happy to note, recalls all the details about the pure meanness of this particular act, that a gun that was fired was then jammed into the victim's forehead. The only way we could have gotten those injuries is if it was hot from that shooting. You'll recall that the man was sitting in his chair and there were bullet holes by where he was sitting, all fitting what he told officers on scene. Those
Object, that's incorrect. That's a mischaracterization of the evidence. There was only one bullet hole that was found, and that was by the forensic analysis or analyst that testified.
There were 2 bullet holes. The argument was whether or not there were 2 or 3 bullet holes. And the record will speak about that. So the end result is, again, it's just not accepting responsibility. If we're going to give somebody leniency, if we're going to give them a break, we look to determine what's their conduct. This man was out on bond on a stalking charge. I'm not going to address whether or not those charges are true or not. What I want to address is the fact that he was indicted, he posted bond, and what did he do? By his own admissions in this PSI, he continued to use methamphetamine all the way up until 2023 when he went into jail. That does not comport with your bond conditions, nor does it's meth is against the law. It's continuing breaking of the law. So if we're looking for leniency, wouldn't somebody's conduct be different? His own records indicate that this man is a menace to society. He has let me count, Judge. He has 8 misdemeanor convictions. Of those misdemeanor convictions, 2 of them were given an opportunity to do probation, which were revoked. In addition to that, he's got 2 felony convictions, all of which I was prepared to prove up to a jury because I did not know they were going to you until the morning of jury selection. Both of those priors, he did not admit to the offense. He was found guilty by juries in each one of those scenarios. And those sentences that are reflected there is what a jury decided. For some reason, he made the option to switch over and allow you to make the decision. It's 25 to life. It just goes to how this man has manipulated the system. We issued writs of attachment for the Knightons to bring him down here. I was prepared to prove it up without him, and I did. But the entire time that the trial took place, we were searching for those people. We were monitoring the jail calls. There was contact between this man and his mother constantly about the trial, all throughout the trial while it was done. And so what happens after we get done? We get a PSI that says they couldn't get a hold of the victims. But ironically, before we start this sentencing, they knew about the fact that it had been updated. I didn't. You're giving that.
Objection.
If I may.
That's incorrect too. I did not learn about that until today when Mr. Noble told me.
Thank you, because that's the whole point. Mr. Noble knew. Mr. Noble knew. Mr. Noble did the conduct. Mr. Noble's history is on trial here. Mr. Noble has done everything he can to manipulate the system, including bringing up his childhood friend. The day of accounting is
This
today.
supplemental report, this was information that the officer received 3 days ago. 3 days ago, so it's new to everybody.
All right. One other thing out of his history. He was given a federal sentence, Judge. So he pled true to what's in front of you that doesn't include the federal sentence. Why I want to point that out for a second is it was not a very lengthy sentence, but as Your Honor is familiar with, whenever someone gets a prison sentence in the feds, they get supervised release. Similar to our probation, but it's post, right?
Mm-hmm. Yeah.
He couldn't make those terms either, Judge. That was revoked. So when you weigh it all out and you separate all these things, we're looking to determine, what's the safest thing for Jefferson County. 12 of our citizens disagreed with the arguments that he's made today. They held him responsible without having heard from the victims. They know that the exposure is 25 to life. I am asking that the court sentence him to 40 years.
Okay. You have a chance to rebut. Go ahead.
Your Honor, I would just point out that Mr. Noble is not trying to manipulate the system. He's doing what he has rights to do. He's calling witnesses to testify on his behalf. He admits that his actions that day were wrong. that he overreacted. He understands that. So he's not escaping accountability or trying to say that he's not sorry and remorseful for the way that things occurred. And so I just want the court to be aware that the statements made by Mr. Ham are incorrect. And that's all I have here.
Anything else you want to add, sir?
Yes, sir. I'm really sorry about all this. And I know this is very serious. And I didn't tell Philip Jones nothing about coming today. He did it on his own. And my mom came to Wednesday in visitation and told me that a man named Riley called. I had no idea what was going on. And my mom said that my stepdad had talked to him. That's how I knew about that situation. But Your Honor, if you send me to prison for a long time like that, I don't know how I'm gonna recover from nothing like that. And I mean, I've been in prison twice, and I tell you, it's just no joke. It's tough. It's hard.
It's supposed to be a
I'm just saying,
punishment.
it's just nobody's down there happy. It's all nothing but a bunch of angry people. And I just think it'll make me way worse if you send me to prison for a long
There's a
time.
way to avoid all of this,
It's just what I-
not to commit a crime.
Yes, sir.
That's what we're here on. But it's a similar crime that you were convicted of before. Aggravated assault. I mean, that's the problem is you're supposed to learn, you got to stay away from this like it's the bubonic plague.
Yes, sir.
It has its consequences. And then this offense was committed in a real inhumane fashion with the gun being, that was just an anger act. I mean, that's meanness. It's not the way you're supposed to treat anyone, much less a close relative. Right?
Yes, sir.
Someone you're supposed to love. What would you do to someone you didn't like? We had 9 prior misdemeanor convictions and 3 prior felony convictions. 2 of those felonies, violent crimes, arson and aggravated assault. And then terroristic threat, harassment, assault, family violence, terroristic threat, assault, family violence. It's 1, 2, 3, 4, 5, 6, 7 other acts of violence. You don't think it's time that you stop committing acts of violence? Anything else? If nothing else, I find as follows, that the defendant has pleaded guilty, has been found guilty beyond a reasonable doubt of this aggravated assault, family violence as alleged in this indictment. Thereafter, being found guilty by a jury verdict, the defendant entered pleas of true voluntarily, knowingly, intelligently to the allegations of prior convictions in paragraphs 2 and 3 of the indictment, where it's alleged the defendant was finally convicted of arson on February 1st, 2001 in the 252nd District Court of Jefferson County, Texas. Thereafter, that became final. The defendant committed the felony of aggravated assault and was finally convicted of that felony in 2010 in this court. And then subsequent to that, he is charged and convicted with the March 17th, 2022 aggravated assault, family violence. So the court finds that there is sufficient evidence supporting the finding of guilt beyond a reasonable doubt, and paragraphs 2 and 3 are proven true beyond a reasonable doubt, which puts the defendant in habitual offender category of sentencing. So he's looking at no less than 25 nor more than life, up to life, 99 years or life imprisonment. That's the punishment range the defendant is looking at. If nothing further to add by anyone, the defendant has been found guilty of this offense, is subject to this punishment range of habitual offender status. The defendant is hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 35 years. And the judgment shall reflect that an affirmative finding shall be made that a deadly weapon, namely a handgun, was used in the commission of the offense. You understand what has happened today? Anything else?
No.
That is all.
Thank you.
Here's this. Thank you. All right, who do we have? Come on up. Ashante? 23 CR 1799 is called. You are Ashante Victor. Here, present with your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary? Yes. In summary, this indictment alleges that on about May 21st, 2023 in Jefferson County, Texas, you committed a state jail felony of credit or debit card abuse. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand? An agreement's been reached where you would be pleading guilty and doesn't say anything. There isn't anything.
It should be 5 years deferred probation.
All right, let me do it. Everybody agree? Proceeding on count one. Confinement, the third, community supervision, 5 years, a restitution in the amount, it seems to be right here.
No fine, Judge, but she's got to pay the restitution.
No. All right, you'd be placed on deferred or unadjudicated probation for up to 5 years. Restitution is owed in the amount of $1,442.74 to the complainant in this case, whose name is listed as the victim in the indictment. Is that your understanding of the agreement? If I follow this, you have no right of appeal. Do you understand? How do you plead to this man, guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct? State's Exhibit 1 tendered, without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I'm going to make findings into the record that support all the allegations as proven true based upon the representations by the defendant in State's Exhibit 1, and find the defendant has pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, but I'm not going to find you guilty. I'm going to place you on deferred or unadjudicated probation for 5 years. You will be ordered to pay restitution in the amount of $1,442.74 to the a victim complainant in this case. There will be other terms and conditions of probation, normal and customary. Please see the probation officer. You will begin today, and you do well, it will be shortened to 1:30. Okay, thank you. That is all. Yes, ma'am. Yes, sir, and yes, ma'am. Thank you. Is there another case to be dismissed?
No, that was it.
No. Okay.
These two people were late today.
Okay, I got it.
I don't know if you're gonna put it in
Got
your
it.
bag.
Here's Jason Noble's
Okay, thank you.
case. The stalking, what are we doing with that?
I was about to ask Mr. Handle.
Not making any decisions till after the appeal time is
All right,
done with Judge.
all
We'll set
right.
it for review in a few months.
Okay, Dwayne Francis,
That's the one, he said he hired Mr. Packett.
4 cases.
He's not.
Is he here?
Doing it today.
Mr. Is that you? Mr. Francis, come on up.
I mean, we can reset it in a few weeks.
And-
Get Mr. Packett in.
Why, what happened to Mr. Blanchett? Did he say he was on his way?
He said he was gonna try to come in, but that's all I know.
When did you hire him?
After the first time I saw him.
How long ago? Weeks ago?
No, it's been a couple of months.
Couple of months.
Yeah, he also worked a case for me in Mr. Holmes and Hardin County.
Okay.
Well, my last court date in Hardin County, he also.
Okay, I need him back in 1 week, and I want him to show cause why he didn't appear like he was supposed to. Get a resetting. I'm sorry that we weren't able to do much. Terrence Killingsworth?
Your Honor, I did check and notice there's a grapple file on that.
Okay.
Yeah, Killingsworth, it was already reset, Judge. He just didn't give me the
Okay,
file.
Patrick Leach, I've got, did you have something else?
Mr. Washington, Your Honor.
That's the NTRP hearing. We're setting off at the end.
Okay, on Patrick Leach, that was David Grove's case.
That was dismissal, Your Honor.
Did we dismiss that?
Brennan Mitchell's, maybe?
Huh?
Yes, sir. Yeah, that was dismissed. You had signed it. Yes, sir.
And then I've got Deryus Baines, John West. There's a motion to revoke. Where's John on that? Did y'all have that case for today? Did y'all notice that?
I had it
DeMarcus
on.
Baines, it's a motion to revoke probation. We were supposed to have a hearing on that.
Motion, Bosh.
It's reset for today.
Yeah.
Okay, we reset. Lacey, DeMarcus Baines reset next week. 1 week, okay, thank you. And then finally, I've got Kashan Washington.
Correct.
Come on up.
Judge, you have Ms. McKinney and Mr. Lori from.
They were late.
Where are they?
this morning. They're right there. They were late.
All right, John, Laurie, come on up.
Yeah.
You were late, your bond was forfeited, a warrant is issued for your arrest, your bond is doubled to $20,000, plus you must have a GPS device. That's what's done when everybody's late.
They said come in and hopefully my lawyer's supposed to, I don't even know who my lawyer is. And I was supposed to just come in and find out if I need to get a court from the lawyer. And I want to hire.
No, I'm sorry, it's.
About an hour later.
It's got your signature on that, and everybody else has signed signature. They sign things and they have to be here. That's an oath you took. Huh?
Someone actually stole my car battery. I was working on my car last night, lift my hood up, and I go out this morning, I shut the hood, try to crank it up, and there's nothing. So I was about an hour and 15 minutes late. I'm so sorry.
The warrant has been issued for your arrest, and your bond was ordered to be doubled. Who is your attorney?
It's Mr. Dusler, Judge.
I've never even talked to him. I think I talked to him for a minute out there.
I'm gonna reset it for next week, okay?
Yes, sir. Thank you.
Here,
Right over there.
you're gonna sign up here and be on time.
Yes, sir. I will.
Thank you.
I will.
Ashley,
Thank you.
come on up. And your bond was also forfeited, and your bond is now $100,000 in a GPS device because it must have been 50 before. Well, it gets doubled when you don't show up.
I'm sorry.
Were you driving with him?
No, sir.
Okay,
And I was in contact with my bondsman the whole time, even before I was late,
so what? I mean, why were you late?
because my ride ended up flaking out on me. Sorry,
Who was your ride?
my aunt.
Well, that's your responsibility.
Yes, sir.
I'm gonna reset it 1 week.
Yes, sir. Thank you, sir.
Don't be late.
Yes, sir.
Come on up. Bye. Yeah. Kashan Washington? Yeah. How long is this gonna take?
No more at all.
Shouldn't be having it at all. It's a motion to quash my motion for revoke probation. No, this is this, all you did was follow this. This is not set for hearing today. You set this for this hearing. No, we're not gonna have a hearing at your whim. We do it for it, so.
Was he gonna plead true to things? No, come on. You don't.
I thought we were doing
You're supposed to prepare like a professional. Come on.
We can interflate.
Huh?
Because it's taking them forever to getting back into.
Yeah. All right, 16 days. Yeah, I'm sorry. She had to go.
Just carefully is true.
How much time is credited on Mr. Washington, please? Thank you. The probation office is here on restitution was almost $13,000. Has he paid any of that?
So there was an amendment signed back in 2018
Okay.
over, because the offense included 5 other defendants. For his part of the restitution, to only be $2,596.50. No payments were made towards restitution.
Since 2018?
Correct.
Okay. Thank you. Okay, in 16-26375, there's a first amended motion to revoke unadjudicated probation filed. You were Kashan Washington, correct? Here with Mr. Kimber, your attorney and the state's attorney. Does the defendant waive a formal reading of this? Can we proceed in so?
He does, remain.
And raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. This states that on June 5th, 2018, in this court, you were placed on 5 years deferred or unadjudicated probation for criminal mischief. Is that true, sir?
You sure? Okay.
Hold on.
Where's your box? Show me your box.
Okay. Earlier, back on December 14th of 2020, the defendant pleaded true to allegations 1, 2, 3, and 4 of this first amended motion in what was called motion, and we continued the defendant on probation. There is a first amended number 5 in this first amended motion that we will deal with, and it alleges that you failed, Mr. Washington, you failed to report to the Jefferson County Probation Office on or about July 21st and August 8th of 2021 in violation of condition 4 of your deferred adjudication order, which states you will report this directly to the probation office and obey all rules and regulations for the probation office. Do you understand what you're charged with here, sir?
Yes.
Is this allegation true or untrue?
True.
Are you pleading true to this voluntarily and because it is true?
If that's all right. This, are you pleading true because it is true?
Yes.
Do you understand that a knowing and voluntary plea of true, that is enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation could be revoked. You could now be found guilty of this underlying charge of criminal mischief, and you could be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yes,
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. All right. Was he an absconder?
Yes, sir.
Since 21?
Yes, sir.
We filed a motion to quash because of lack of due diligence.
Oh. Is that what we said?
Yes, sir. I expect it to be overruled. What I'm requesting is maybe we can reset it for 2 weeks for sentencing, and that would give him some time to perhaps pay some of the restitution before he's sentenced.
Where's he gonna, wait. You've been on probation for going on 7 years. And now you're gonna pay restitution? Where are you gonna get that?
I had the job.
No, where do you have, how much do you have right now to pay? Right now,
About $500.
sir?
About $500.
Maybe the family could contribute.
Yeah.
Maybe. What state say? The court just doesn't want to be held hostage. For 7 years, a court's order was in effect. And then here, 7 years later, when you're arrested before the court, you're looking at possibly getting revoked. And then you're going to look into getting restitution. I want restitution for victims. That's very important to this court, very important. But not being held hostage to your terms and your timetable. That's a court order. You don't order the court anything. You have to respond to the order. 7 years has been a long time to not pay a dime and then scamper off for going on 4 years. Where you been? Where have you been?
That's right. Working.
Where have you lived? How do you just?
Where have you been? You haven't been coming to obey the court orders.
Where have you resided? What address have you resided in? Speak up.
5745 Falcon East.
Beaumont. You're on the 5 years. Your relationship is gone. All right. Answer.
Yes. This week, about where I normally am. What was the street name?
What was the street name?
Falcon.
Like a bird?
FALCL.
You might want to talk to Jason.
What are you asking for?
2 weeks for sentencing and see if they could pay any of the restitution. And then to get a ruling on that motion to quash.
Judge, first of all, that motion to quash is referring to not using due diligence. It has nothing to do with whether there's allegations stated. It's not the proper venue. Proper venue for challenging that, according to the statute itself, is an affirmative defense, and they have to prove it. And then they can have an issue. A motion to quash is not the avenue that you challenge the affirmative defense with.
Yes, it should be over. The state's arguing, which is.
Yeah. The state has, the court is considered a motion to quash the motion to revoke prohibitions filed on May 13th of this year, and the defendant, the motion to quash the MTRP filed on behalf of the defendant is denied and overruled. Go ahead. What are you asking for, Stan?
Judge, this was some people that tore up our school, one of our schools. They broke in and started destroying things in the school. And then he just absconds and doesn't pay. I don't care if he pays restitution, great. I'm still recommending the full sentence for the 2-year state jail.
What's the difference? What's the difference?
I would defer that. Our course, we're asking for de minimis sentencing, but I know that would be contingent upon partial or the restitution. We're asked that in good faith.
All right. Anything else you?
So I'll defer the recommendation till sentencing.
Okay, well, today, that's the sentence.
Well, I'd like to reset it for if the court's not inclined.
We're moving forward today.
So
if something happens that you're asking if they can, all right, I got 30 days.
for new trial.
Mhm.
Well, Your Honor, obviously, I'll let Mr. Washington address the court's forces, failures, and omissions in complying with probation. What he's been doing as far as the 4 or 5 years that he's not been reporting. He's expired. I don't know the court. It's past time.
That's not a good sign. That's not a good word.
I don't think he could be extended now. So that's not an option.
No, I don't think so. I think it is. The First Amendment motion tolls.
Well, if it tolls it, then I would say extend him and
try to get some of the restitution out of him. If
Anything?
the court be inclined to extend it.
Yeah.
What do you want to tell the judge?
I know I have an opinion.
You haven't done anything for years.
You do it.
Walked off the job. What happens when you're at work and you walk off the job and never come back? You get fined.
Yesterday was a long time.
Anything else?
I think that's all.
All right, you're pretty much fired, if you know what I mean. I'm going to grant this first amended motion to revoke unadjudicated probation as the court finds allegation 5 is proven true beyond a reasonable doubt based upon the statements of the defendant knowingly, voluntarily admitting that he failed to report on July 21st, 2021 and August 8th of 2021. And again, from the probation office, I don't think I swore you in. Raise your right hand. Do you solemnly swear or affirm the testimony and statements you make today will be the truth, the whole truth, and nothing but the truth, so help you God? And then are you reaffirming that he has been an absconder since he reported he failed to report on July 21st, 2021. He has been an absconder ever since.
Yes.
For years, and has not reported until he was finally arrested. It's fortunate. Is that true?
Can I ask her a question?
Is that true?
Yeah. Were any efforts made during the 5-year period you acknowledge that executed warrant at his address as indicated on the file? Do you know the person?
Do you know anything about that?
Attempts were made to locate the defendant at his house, by law enforcement. I can't give an answer on that. That's.
But what you did, you tried
The
to,
probation department did, reach out via telephone and mail correspondence.
and that location was the last location that the defendant had told you he lived at?
The last location on file is on Pinchback.
Okay, and who gave you that information?
That was in his file.
What does that mean? What's normal and customary? How do you get that information? From the defendants?
From the defendant, correct.
I mean, that's their address. Are they required, as a condition of probation to report any change to make sure that you know about any change of address? So that they can be, first of all, that it would have to be approved by the court, but are they required to ensure that you know what their address is?
Yes.
But most importantly, he had regular probation, what, monthly?
Yes,
And he's missed 5 years of that, or 4 years.
correct.
As he absconded. And when, as far as your information, the defendant was arrested, he didn't report back on his own, correct? I find this first amended allegation 5, failing to report to the Jefferson County Probation Office on or about July 21st and August 8th, 2021 in violation of condition 4 of your deferred adjudication order. That is proven true beyond a reasonable doubt. And that is a violation of your probation. And thus, this first amended motion to revoke unadjudicated probation is hereby granted and your probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood, appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense of criminal mischief. You are hereby sentenced to confinement in the state jail for 2 years. What is the restitution? It shows $12,982.49.
I think they're jointly and severally liable, Your Honor. If you apportion it, if what she had indicated.
$2,596.50.
But like you say, they're jointly and severally. So the judgment shall also reflect restitution is part of the judgment in the amount of $12,982.49, restitution to be paid to the victim in this case, which is Ozan High School here in Beaumont, Texas.
And he would be entitled to an offset
Yes.
for that amount to the extent that the other
Should.
defendants have paid.
Should, we're not, the total amount of restitution to be collected is $12,982.49. Each defendant, though, is jointly and severally responsible, thus, which practically means if others can't pay, someone who can is going to be responsible. But that is what the judgment shall reflect, is restitution, as if and when money is found and credited, then the court can take up the fact that only a portion of that was obligated. If others have paid, it's credited. It will be credited against the restitution if others have paid. All right, I think that's clear enough. Anything else? That is all we are in recess.
Get them from us.
A second. Come on back up here. I might have got these out of order. What's your name again? Thank you. I'm sorry. Thank you. Brittany Nicole Brown, 25T645283. Your name, ma'am? No injuries, minor damage. They're offering impeding, right? Is that what you want to do?
Yes, please.
To that charge, responsible or not responsible? Please accept it. Original charge dismissed, 195. Cash you into the hall to your right. Good luck. Devin Kyle Kersey, 25W838429. Your name?
Devin Kersey.
Okay, so I'm not trying to talk you out of having a hearing. It says you want an informal, right?
Yeah.
Did they offer you impeding or no? Okay, I see. All right, so we're gonna set an informal on this. Lisa, if you can give me a date. It's Officer Meadows from Woodhaven.
June 12th at 9 o'clock.
June the 12th, sir. June the 12th at 9 a.m., okay? Thank you. Go down the hall and they'll give you a notice, okay? People against. Fernando J. Rodriguez Hernandez, 25W838619. Your name?
Fernando Rodriguez.
Have a seat a second, will you?
Yeah.
1 second, right there at the table. Have a seat. Just have a seat right there. I'm gonna check on something.
Okay.
A seat.
I'm sorry, I don't know, speak English, so speaking a little bit.
Okay. Can we get the department rep? Let me see here. It's Woodhaven. Lisa, do you have an extension for me? Woodhaven reps are in courtroom 2, it says.
They're
So-
all in the actual courtroom because we're out of conference rooms today.
I see. Okay. Detective, can you do me a favor, please? This young man was speeding, and I'm not condoning it. He's going 87 and a 70. I've seen worse. He's got 2 priors. I think it merits impeding.
Yes, Your Honor, absolutely.
Would you go talk to him, please? Just have a seat, that table there. Go talk to the department rep and see if you won't consider changing that. Will you do that for me, please?
That would be me.
Oh, that was you?
I would be happy to change it. yes.
Okay, good enough. Sir, have a seat, right there. No. Just show him where the table is. There you go. Megan Elise Godowski. Chew 5F 243574. Your name? How you doing? Not too bad. You're going to plead impeding traffic, correct? To that charge, responsible or not responsible? Please accepted, speeds dismissed. 170 is your total. You can go down the hall and make your payment. Good luck. Thank you. People against Wilkie. Christopher Carl Wilkie Douglas. 25F243773. Good morning. Your name? Nice and loud. All right. You're going to plead to impeding traffic, correct? All right, to that charge, responsible or not responsible? Responsible. All right, I'm going to accept the plea. 165 is your total. Cash your end of the hall to your right, okay? Good luck. Stone. Travis James Stone. 25B41484441. Podium, please. Your name?
My name is Travis Stone.
All right, you want an informal?
I'd like to appeal, but the guy was trying to give me 105 for a ticket.
It's up to you. There's no appealing. Hang on, slow down. You haven't pled anything. There's no appealing. If you want to have a hearing, I'll give you a hearing. If you're convicted of this, this is a 2-point civil infraction. I just want you to be aware of that. Hang on. I know you wanted 0 points. You know how many times I've heard that? You can't go out and constantly get tickets and expect courts to say, okay, we'll give you impeding again. I'm sorry, that's just not the way it's going to work here. So if you want to plead to 1 to 5 over, I'll send you back. If you don't, I'll set it for informal. If you're convicted on the failure to yield, it's 2 points.
Okay, I'd like to go to a court.
Okay, good enough. We'll set an informal hearing. Lisa?
June 12th at 9:15.
June 12th at 9:15, okay? So you can go right down the end of the hall and get your court date.
Okay, thank you, sir.
Thank you. Good luck.
Thank you.
McSchroeder. Bridget K. Schroeder, 25B148275. Name?
Bridget Schroeder.
All right. You're going to plead to impeding traffic?
Correct.
Was anybody hurt here?
No.
Okay, it doesn't say anything about injuries. All right, to that charge of impeding traffic, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the original charge, 195, you're all set. Cash your end of all to your right, good luck.
Thank you.
You're welcome. Michael Andrew Friedman, 25B148563. You can come up this way, sir. Okay, I'm sorry. Your name?
Michael Friedman.
All right. You gotta be careful. You're gonna plead to impeding traffic, right?
Yes, sir.
You gotta be careful though. I mean, you got some entries here. You're hardly qualifying. To that charge of impeding traffic, responsible or not responsible?
Responsible.
All right, please accept it. 175, cash your end of all to your right. Good luck.
Thank you.
You're welcome. McIntosh, Jacob Gregory Dalton McIntosh, 25B148132. Your name?
Jacob.
You gotta slow down, okay? You're gonna plead impeding? Is that, and that's what you wanna do, correct?
Yes.
to that charge of impeding responsible or not responsible? Please accept at 150. Cashier end of the hall to your right. You're all set. Good luck. Is anybody with Mr. Rodriguez Hernandez? Who? Anybody with you? Come on up here. Fernando J. Rodriguez Hernandez, 25W838619. Your name?
Fernando J. Rodriguez Hernandez.
All right. I want to make sure you understand me. Can you understand me?
Yeah.
So I've got this, I talked to them, you called them in here. He's going to allow you to plead to impeding traffic. That's 0 points. It won't go on your record. It's better than the other deal that you had, okay?
Okay.
Do you understand that?
Yes.
0 points. To the charge of impeding traffic, do you plead responsible or not responsible? Okay, I'll accept your plea, dismiss the limited access charge. You got to slow down though a little bit, okay?
Okay. Thank you.
All right, wait a minute. Slow down. Slow down. Come on back. Come on back. 170. 170. Okay?
Yep.
Good luck.
Yep.
Shear. Brendan Christopher Shear, 25R514124. Mr. McDermott, your appearance. Is he out there, Lisa?
Yeah, he's coming in right now.
All right.
For some reason, it went to a breakout room. I'm trying to move him. Oh, there he is.
There you are. Mr. McDermott, your appearance.
Good morning, Attorney Sean McDermott, P46101, on behalf of Brendan Shear.
All right, so you're going to plead impeding. You're authorized into this agreement with the with on behalf of your client, with the understanding the improper lane use will be dismissed. Correct?
That's correct, Judge.
That charge impeding traffic, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the original charge 235, and I'm going to give them until June the 13th. Okay?
Good to see you, Judge. You're a YouTube sensation. I've been watching some of your videos.
You know, a friend of mine, his name is Ron Muir. He's from Florida. He's very good friend. And he bugs me to get on there. Bugs me. Calls me up afterward. Boy, that was so. Jeez. I don't know. He likes watching. He's retired. He doesn't have enough to do, I don't think. He's a good man.
Yeah,
he's a good friend. So
you probably got at least 10 of them out there.
What's that?
You probably got at least 10.
Oh, jeez. Well, good to see you, Mr. McDermott. Take care.
You too.
Bye now.
Take care, Judge.
All right. So we have Chavis. Abro Lachey Chavis. 25B1474001B. You know, if you guys are on this side of the courtroom, I'm just telling you, if it's easier, you can walk up this way. If you're on this side or over on the right, your left side of that middle, the biggest row there, you can come up through these doors. Your name, ma'am? You're charged with failure to pay fines and costs of $225. If you plead guilty, or if you're found guilty, you have no prior technical violations, you could get 5 days. Do you understand that? Did you sign the advice of rights and read and understand the rights? If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? All right. Okay. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
Sure.
You have the money.
Not today.
How much do you have today?
I can probably pay 50 today.
All right, okay. If you want a lawyer, I'm gonna give you a lawyer. Hang on. Listen. If you want a lawyer, I'm gonna give you a lawyer. If you don't want a lawyer, I'm gonna set up a payment. But you understand that? I'll set up a payment plan with you, but you were supposed to pay that day. Why didn't you pay that day?
I honestly was pressed for time and I had thought about
coming back to pay it, but because I had to be at work by a certain time. And I honestly forgot about that. I forgot. So my work schedule was crazy. I work 7 to 4:30.
Where do you work?
I work for Corwell and Dearborn at the cardiovascular center. I work 7 to 4:30, so I was.
I know, but you can't just walk out of the courthouse when you're telling the judge you can pay that day, right? You can't do that. All right, you have $50 now?
Yeah.
I'll dismiss the show cause, but don't do this again, okay?
Okay.
If you didn't have time, you should have told me. If you didn't have time and had to leave, under no circumstance should you have done that without saying, can I pay tomorrow? You should come in the next day. You can't do this, okay? All right. You pay 50 today, when can you pay the balance?
Can I have it paid by my next court date, the 18th of June?
You have a court date?
Yep, June 18th.
With who? What's that on?
I believe for probation.
Oh geez, you want to get this case thrown, you want to get this dismissed?
Oh, so the sooner I pay it, you get.
Well, no, you got to come in the 18th. You pay by what day of the week is the 17th? Should be, let me see here.
It's a Tuesday.
You pay by the 17th, okay? You pay 50 today and the balance by June the 17th. And then you're coming in here on the 18th, and if everything's in order, you're going to have your case dismissed, okay?
Okay, could I pay online?
Yeah, you can pay online.
Okay, because my job not really off 2 days in a row.
Well, you don't have to, you can pay online.
Okay,
You go down the hall, pay your 50 now.
okay,
After that, you pay by the 17th. And there's no charge for it.
okay,
Just pay the balance, okay?
okay.
Don't do this again. Good luck. You got too good of a job. You're too smart to do this. Frank DeMar III. Have a good day.
Thank you.
25W838508. How you doing?
In court, doing fantastic.
What's that?
So in court, I'm doing fantastic.
Why, you like coming to court?
I love it.
You're gonna plead to impeding, right?
Correct.
To that charge, responsible or not responsible?
Responsible.
Original charge of distract is dismissed. I'll accept your plea to impeding. 150, you're all set.
Thank you, Judge.
Have a good day. Carrie Elizabeth Chaffins, 25W838626. Could I have seated at the table Amber Manley? Jacob McIntosh. Your name, ma'am?
Carrie Chambers.
Okay, so you're just gonna plead to impeding, right?
Yes.
Okay, they just warned you on the speed. You gotta,
Yeah, I kind of meant to make a payment plan online and I must have set up a court date, not paying attention to what I did
that's all right.
online.
To the charge impeding traffic, responsible or
Yes,
not responsible? Why are you driving so fast?
Honestly, I was a bad day and I was.
Why was it a
day. I
bad?
left my husband that day. It was
Oh,
a
no,
bad day.
jeez.
I just kind of was.
All right, you don't need to tell me. 150 is your total.
All right, thank
And
you.
you accept, and you're pleading to impeding, correct? All right, go down the hall, take care of that, and you're all set.
Thank you.
And you have the money?
No, I don't.
What do you
It was
have?
supposed to be set up as a payment plan.
What do you have today?
I don't have nothing today. I get paid on what is today actually?
This is the 29th,
I get paid
Thursday.
on the 7th.
Okay.
Come back in on the 7th.
So let's see, the 7th is a Saturday, so you pay
So I'll
by
come in-
June the 9th.
Yep.
Pay by June the 9th, 150. If you need more time, you don't have the money, come in, talk to me on it before the due date or call, and we'll go on Zoom, and I'll be happy to give that to you, okay?
Okay, thank
Good
you.
luck, Ms. Chafins. Amber Manley. Amber Karen Manley, 25F243774. Where's Jacob McIntosh at? Your name? Hi. Is there a Jacob McIntosh?
Judge, he had two cases and he came down to the window. We thought they were both addressed. So he's on his way back.
Oh, okay. Ms. Manley, I'm sorry, tell me your name again.
Amber Manley.
You gotta slow down and be careful here, okay?
Yeah, guys swerved at me, and then I took off kind of fast.
That you,
I should have tried to slow down, so yeah, I meant I did.
you gotta slow down, and be careful.
Yeah, but the man, black truck swerved at me, I'm driving a little 08 Pilot, and
The charge impeding, responsible or not responsible?
responsible.
All right, I'll accept the plea. 175, speeds dismissed, cashier under the hall to your right. Good luck. McIntosh, Jacob Gregory McIntosh. 25F243923. How you doing there, Mr. McIntosh? Your name?
Jacob McIntosh.
Okay. You're going to plead as charged to impeding, right? Responsible or not responsible for that charge? Pardon? I'll accept the plea. 150 is your total. Cashier under the hall to your right. Good luck. Keith Bradley McKeel. 25T645318. Good morning. How are you? Your name?
Keith McKeel.
Was there serious damage to the other vehicle?
Wasn't too bad. I was only doing 20 miles an hour when we got brakes give out.
The brakes gave out?
Yeah, I was lied to by my truck boss, which they've since fired. So that the truck was serviced and it never was.
He just wrote no injuries. You were going 20.
Yes, sir.
To that charge of impeding, responsible or not responsible?
Responsible.
270 is your total. Cashier under the hall to your right. Good luck. Yisu, Ricardo Michael Yisu, 25T645528. Your name?
Ricardo, yes.
So how'd you manage to strike a pole?
I passed out when I was driving, trying to get to the hospital to see my daughter.
Is she okay, I hope?
Yes.
Good. All right, I'm glad for that. All right, so you're gonna plead to impeding, right?
Yes, please.
Responsible or not responsible to that?
Responsible.
All right. $200, cashier under the hall to your right. Best of luck.
Thank you.
Zakaria Muna. 25T645285. Yeah. Minor injury to defendant, major damage to defendant vehicle. I'm assuming. Your name? So nobody was hurt in the other car? I can't hear you. Was anybody hurt in the other car? Okay. Have a seat 1 second. We're gonna have to get Lieutenant Greeno in here. Have a seat right there. There you go. Ernest Phillips Stewart. 25B148541. Good morning. Your name? Name? You're going to plead to impeding, right?
Yes.
Responsible or not responsible to impeding traffic. Please accepted. 160 is your total. Cashier end of the hall to your right. You're all set. Good luck.
All right, I have a question. By being the first of the month, can I make some kind of payment arrangement?
Yeah, when can you pay this? June 5th?
I'll pay half today, and then 2 weeks the other half.
Okay. You pay, so you got 160, you pay 80 now.
Yes.
Balance by, we'll just make it June the 12th. Okay?
All right, great.
Best of luck. If you need more time somehow, come in here and talk to me, okay?
All right.
Good luck. Deborah Jean Malloy, 25B148574. Good morning. Your name?
Good morning.
It's nice to see a smiling face in here from time to time. All right, you're gonna plead to impede?
Yes.
Responsible or not responsible?
Responsible.
You got a clean record, 150 is your total, cashier end of the hall. You're all set. Best of luck. Thank you. Lieutenant.
Sir.
I want to make sure there's no injuries on this case to the other side. You said injuries to defendant, injury.
Yeah, he said he had slight shoulder pain.
What about the
He
other?
said, no, I don't have access to the crash report, I can call his rep.
Yeah, do that, thanks. I want to make sure when you send those in, that there's no injuries to the other person and no serious damage at least to the other car. Stephanie Ray Podlasa, 25B148456. Your name? Good morning to you. You're going to plead to impeding traffic, true?
Yes.
To that charge, responsible or not responsible? Please accept at 170, cashier end of the hall to your right. You're all set. Spencer Charles Langley, 25B148483. Informal, Lisa. Okay, sir, your name?
Special Langley.
You want an informal?
I want to contest traffic citation, in 2025.
That's fine. We're gonna give you a hearing. Well, you don't need to, I just wanted to make sure that's what you want. Give me a date, Lisa, please.
June 11th at 9 o'clock.
June the 11th at 9 a.m. You go down the hall, they'll give you your notice, and you come back here on the 11th at 9 a.m.
Thank you so much.
Okay, good luck. Ivana Odilia Ortega, 25W8382620. How you doing, ma'am?
Good morning, I'm good, how are you?
Your name?
Yvonne Ortega.
You're gonna plead the impeding?
Yes, sir.
Responsible or not responsible?
Responsible.
Why are you using a phone?
I know, it was careless.
You know, I see people do that. It shocks me. They're flying out, they're going over the divider lines. It's like, really? Pull over and go on the rest area. I don't get it. As much as we're talking about this, please don't do that
I
again.
won't.
Okay, to that charge of impeding, responsible or not responsible?
Responsible.
Okay, I'll accept the plea. 215 is your total. Cash your into the hall to your right. Good luck. Thank you. Please don't do that again. Caitlin Renee Duchesne, 25F243888. Now I'm feeling really, your name? I don't mind telling you. You're right around now. I'm feeling really old. You gotta be careful though, okay?
Okay,
All right? Right?
yes.
Okay. I mean, I am old. What are you, 16?
I'm 17.
17, okay. You're practically ready for retirement. To that charge of impeding traffic, responsible or not responsible?
Responsible.
Where do you go to school at?
What have you been?
Yeah, how's it going?
Pretty good.
Senior or junior?
Junior.
What are you gonna do in 2 years?
I'm not sure yet.
You're studying hard though, right?
Yeah.
All right, 195, good luck, you're all set. Cashier, please be careful, okay?
I will.
Riley Jean Wampler, 25F243839. Good morning. Your name? What are you doing here? Let's see. What do you have?
I have a speeding ticket on that car. I just want to change it to an impeding traffic.
Okay, you want to do that? All right, to impeding traffic, responsible or not responsible?
Responsible.
Please accepted, clean record, 150. You're all set. Good luck. John Angeles. You can come up right this way. There you go, 25W837-516. Could I have Gamal Shohadi seated at the table there, please? My right, your left. Come on up to the podium, sir. What's your name?
My name is John Angeles.
All right, so you got your ticket back in January.
Yeah, I forgot about it. I had a baby in February, I forgot about the ticket. So that's why I'm here, so I'm trying to ask for more time because my work is slow right now. So I just want to pay it the following week.
All right, listen. Don't do this again, okay?
Yeah.
You don't have the money, nobody's an ogre here. You come in and talk to us, don't ignore us. This is 4 months later, you shouldn't have done this. When can you make your first
I
payment?
can give my first payment Friday next week.
And how much can you pay
I'm
them?
gonna pay him for $320.
Are you sure?
Yes.
Show cause dismissed. Next Friday is June the 6th. June the 6th, right? Yeah, June the 6th. You have to pay a clearance fee, $45, because you're suspended right now. I hope you didn't drive here. If you did, you
No, I
didn't.
have my mom driving.
All right, good. Well, don't drive until you pay this. I'm gonna reduce the balance here. You owe 282 plus 45 for 327. The 45 is your clearance fee. I'll reduce the balance, at least you came in here, to $215 plus clearance fee. So you're gonna have to bring in $260 to get your ticket taken care of and your clearance, so you're not suspended, okay?
Thank you.
All right, best of luck to you. If you need more time, come talk to me. Come on up, Lieutenant. Do you have that information?
I do. It looks like it was disabling damage on the other car and possible injury, but it doesn't say.
Yeah.
severity.
Courtney Dale, wait a minute, what's his name again?
Is that right?
Was it, what's your name, sir? What did I do with that?
I have it, Judge.
Oh, you have it. Thank you. I thought I was going crazy here. All right. Zachariah Wana, 25T645-285. So it's just, your name again?
Lieutenant Green.
So it says possible injuries?
It's a complaint, but nothing visible. What the code saying.
I just don't like doing that when they have a complaint of pain. I mean, does he speak good English?
I don't believe so, sir.
But it was disabling damage.
It looked like both cars had to get towed.
I just don't want to do this. I'm sorry. I'll give you 5 over. If you want to give them 5 over. If you want me to get you an interpreter, what language do you speak?
Arabic.
Okay. If you want me to get you an interpreter, I will. I don't feel comfortable.
We can work with the 5 over. I'll take it back.
Okay, I just want to make sure that, yeah, go do that if you would, please. Thank you. And if he needs an interpreter, if he doesn't understand, I want to get him an interpreter before he pleads to something he doesn't understand. Gamal Abdo Shohadi. Shohadi? 25T645-286. Come on up here, sir. Your name? Good morning. You're going to plead to impeding, right?
Yes, sir.
To that charge, responsible or not responsible?
Not responsible.
Please accepted. 165, original charge dismissed. Cash, have a good day. Courtney Danielle Gaither. Courtney Danielle Gaither, Gaither, 25T645-367. Is she on Zoom or something?
No, not on Zoom.
Can you have them yell for a Courtney Gaither down there, please? Just call Will. Charvet Gaskow, 25T645, 437 A and B. How you doing?
Hi.
Your name?
Charlotte.
We're gonna set these standard formal, right?
Yeah.
Did they offer you anything?
I over. But I wasn't speeding. I pulled over at, my car's parked there.
All right, so I don't need to hear this. I'm not saying you're right. I'm not saying you're wrong. Somebody thinks, just listen to me, please. Somebody thinks you were going 70 and a 50.
Yes.
I'm not saying they're right. I am telling you that if they are right, you're gonna end up with 4 points. If you want to take their offer of 1 to 5 over, that's 1 point. I'm not trying to talk you into it. I'm not trying to talk you out of it. Okay, all right, good enough. We'll set them for informal hearing on both charges. June what, Lisa?
June 11th at 9:30.
June the 11th at 9:30. Okay, ma'am, you could go right down the hall and get your notice. We'll see you back here. I'm sorry? No, out the back there and to the end of the hall to your right. All right, now. Courtney Danielle Gaither. Where were you?
I'm so sorry, Your Honor. I was sitting right outside the door. I was told to sit in the lobby after I went in that bathroom.
All right,
I sit right there.
okay, what's your
Very
name?
sorry.
What's your,
Courtney Danielle.
you're fine. So you're going to plead to impeding traffic, right?
Yes.
There's a disobeyed traffic signal, no accident. For that charge, you plead responsible or not responsible to impeding.
Responsible to.
Okay, I'm gonna accept the plea. You've had a couple accidents here, right?
Yes.
You're impeding on those?
One of them.
You gotta be careful, okay?
I understand.
170 is your total, original charge dismissed. Cashier into the hall to your right. Good luck.
Thank you.
Later today.
Yes, yes.
Can you see if he's got anything ready? And he can bring them in and I'll get him out here on whatever he's got. Gregory Antonio Crisp Jr. 25B147 999. Your name? So I'm not a fan of these operating while texting. I've seen enough damage of my own to watch people. They're driving all over the road. You can't be doing that, okay? So that charge of, you're gonna plead to distracted, right? That's 0 points. I'll dismiss the operating while I'm texting. To that charge, distracted driving, responsible or not responsible? I'll accept the plea, dismiss the original charge, $200. You can go down the hall and take care of that. Good luck.
Can I pay that Monday?
Yeah. Please don't do this again, okay? Pardon? June 2nd. Good luck. Thank you. Star Cashmere Gaziblo, 25B148578. Same thing here. Your name? Your record. It's not very good. Why are you texting? Why are you can't do that. You know you can't do that. Why are you doing that? I mean, I'm shocked that we don't have so many more accidents anymore. I'm gonna go out of my way and rationalize why I'm gonna do this, okay? But please don't do that. All right? We got each other? All right. To that charge of distracted driving, responsible or not responsible? Please accept it. $230 is your total. I'll dismiss the original charge. No more of that, okay? Thank you. Marine Shahzadi, 25B148614. Good morning. How are you? Good. Your name? All right. You're going to plead to impeding, right?
Yes.
Responsible or not responsible to that? I'll accept the plea. 195. Cashier into the hall to your right. Good luck.
Can I pay that Monday?
Sure. June 2nd.
Thank you.
If you don't have the money, call the court. We'll go on Zoom or you can walk in here on that date at 8:30 and I'll give you an extension, okay? Just don't ignore me. Patrick Sean Quinn, 25B147845. Good morning.
Morning, Your Honor.
You're going to plead to impeding, right?
Excuse me?
You're going to plead to impeding traffic?
Yes, Your Honor.
All right, to that charge, responsible or not responsible?
Responsible.
I'll dismiss the failure to stop assured clear distance. $200 is your total. Cash your end all your right. Good luck.
Thank you.
Brooks. Jila Bridget Brooks. 25F243698. Does Gabe have anything ready?
I called him and texted him, he didn't answer.
Good morning. Your name?
Good morning, my name is Jayla Brooks.
Give me 1 second if you would.
Yes, sir.
Roger, do any of these guys have pre-tried cases with any of these guys? Ask them to, I haven't had a file from you guys yet. Ask them to come in here with their files and their clients, and I'll get them started. Thank you very much. Okay, how are you?
I'm good this morning.
Good, your name?
Jayla Brooks.
So you can accept responsibility to expired plate. Plate had been expired for 2 months. You have your registration now?
Yes, I do.
To that charge of expired plate, responsible or not responsible? I'll accept the plea. Look, I'll cut it down a little bit, 115, but you gotta have a valid plate, okay?
Yes, sir.
Thank you.
Thank you.
Cash your end of the hall to your right. Abdul Rahman Nasir Ahmed, 25F243829. I need Ahmed in here too. Do I have Mr. Ahmed here anywhere?
Yeah, that's.
Oh, okay, did somebody, Abdul Rahman Nasir Ahmed, 25F243829. Your name?
Yeah, after what then?
What is somebody telling everybody to go in the hallway?
He told us to stay up there when we were out there, so like when we were on time, he had us like stay out there in the hallway. And now.
You mean after you met with the department rep?
Yeah.
Who's saying that? Which one?
What was his name? He's the guy with, for the crutches, arm crutches. I don't know his name. Forgot his name.
That's Mr. Gaith. That's not for department reps.
I got it, okay. Because we've had to go out a couple and the last one had said that. You're gonna plead to impeding, right?
Yeah.
Responsible or not responsible to that?
I'm guilty.
Do you plead responsible?
Yes.
Okay, I'm gonna accept your plea. $170, cash your hall to your right, and you're all set. Good luck. Thank you. Ashley Hill. 25T645410. Boy, they're being awful generous back there. I think I got a bunch of lawyers in here. Your name?
Good morning, sir. My name is Ashley Suzanne.
What happened? I'm curious. You didn't have insurance.
Correct. I believe that the date that my insurance expired was May 5. I'm sorry, that it was, yes, it was May 5, and it ended up being April 5.
You gotta be careful. That's a 1-year misdemeanor, okay?
Yes, sir.
All right, they want to dismiss it. I'm just a pawn here. Case dismissed. You can't drive without insurance. You want to get yourself in trouble, get in an accident. They'll be coming after you till you're 92.
Absolutely, sir.
All right.
Wrote it on my home calendar.
Good,
my
good,
journal,
good.
and
Good
my
luck.
calendar.
You're all set. Thank you.
sir.
Which ones do you have? You have some ready?
I got one ready. I'm also overflow today.
Who's the lawyer? I haven't seen a lawyer in here yet.
Amazing is house counsel.
What's that?
Amazing house counsel, but there's no overflow. Some they have some personal things about overflow.
Oh, okay.
Right, you want to stay from that?
Yeah. I'll.
So Johnson, go back home.
How you doing?
Mr. Gates said he's finishing something up. He'll be in with 6 files.
Okay. All right.
I'm tired of getting yelled at by me. I've had.
Whew.
I took care of it. We'll talk. I took care of it. Okay.
People against Mathis, Robert Stephen Mathis, 23B142591A and B.
Morning, Your Honor. Michael Crawford representing Mr. Mathis. Approaching, consider your name for the record.
Robert Stephen Matthews.
Okay. What's he doing here? Have a drug paraphernalia and a suspend.
Your Honor, my client would like to stand in the formal reading of the charges.
Okay. Did we talk about where he's been for 2 years or not last time?
We can, Your Honor. It's not a good explanation.
I can't wait to hear it. Tell me.
It's a pretty good one, Your Honor. My client became gravely ill. He had to undergo quadruple bypass heart surgery.
That's not good. All right, I've heard enough. Personal bond, $1,000. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. I'm going to give you a $1,000 personal bond. It's hard when these are so old, but you're going to AA at least twice a week, AANA at least twice a week. That's a condition of your bond. He's going to hand you a form. You have to go in person. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. AANA twice a week. Every time you go, you have to have that form signed. every time you come to court, you have to bring the form with you to evidence that you've been going. You understand that?
Yes, sir.
All right, so if you want a court-appointed lawyer going forward, you'll have to fill out a petition for one. I'll likely grant it. I'm gonna give you a pretrial date, and that will be on,
Should be on the front, Judge.
June 18th. Sir, June the 18th at 10:30 in the morning. So you're gonna fill out your petition right there at the table. When you're done, you hand it back to my court officer, and then you go to down the hall and you'll get your notice, okay?
Yes.
June 18th. Any questions?
No, sir.
All right, best of luck.
Thank you.
Thank you. Mikhail Seelig, 25F243948, A and B. Your name, sir?
My name is Mohammed. This is Mikhail. I'm here to translate.
Okay, what language?
Turkish.
And you speak fluent English?
I do speak fluent English, but I could translate to Google. I can speak Turkish.
Say that again?
I don't speak Turkish, but I could translate through Google Translate.
Okay.
Yeah. We both work in the same restaurant. And,
What restaurant?
Turkish Village, the Dearborn.
Okay. All right. Tell him to tell me his name. Can you repeat what he said for me? Yeah, you.
Mikhail Chen.
All right. So you're gonna just translate now.
Yeah, translate through Google. Google
I have a stipulation here that says that you are going to plead responsible to impeding traffic with the understanding that the speeding will be dismissed. And they got you going 25 over. So when you're done translating that, tell me. Is that what you want to do?
Yes, sir.
To the charge of impeding traffic, responsible or not responsible? You're gonna have to take your hat off back there.
Sir, you gotta take your hat off.
Responsible, sir.
To the charge of expired plate,
Yes.
responsible or not responsible?
Responsible.
Say that again?
Responsible.
Responsible?
Responsible.
Okay.
I'm sorry, sir.
You talked to him, right?
Yeah.
All right. You gotta slow down. I'll accept your plea to impeding traffic. I'll accept your plea to, are you telling them this? To expired plate. 170 on the impeding traffic. 120 on the expired plate. Totals 290.
Thank you so much, sir.
Can you pay that? You can pay that, sir?
Thank you so much.
Jeez, I wish everybody was in here smiling like you. And between you and your interpreter here,
We appreciate it. Thank you so much.
have a great day.
I have a blessed.
Good luck. Thank you.
Thank you so much.
Cody Lee Mathis. 25B148610. What's your name, sir?
My name is Cody Mathis.
How you doing, Mr. Mathis?
I'm doing all right.
So you're 18, 17.
17, yeah.
All right, to the charge, you're gonna plead to impeding,
Yes, I am.
responsible and not responsible.
I'm responsible.
All right, and you're gonna slow down a little, right?
Yeah.
150 is your total. Please accept it. Speed's dismissed. Cashier into the hall to your right.
Thank you.
Good luck. How you doing at school?
Graduated today, or should be graduated.
From where?
Today.
Good. What are you gonna do now?
Hopefully go when I'm 18.
You're gonna hopefully what?
Well.
Oh, good.
18.
All right, good luck. Thank you. Ahmad Mohammed Alpha Bobby. Alpha Bobby. 25W388521. You have to take your hat off, sir. Is Alpha Bobby in here? He's on Zoom.
Not on Zoom.
Oh, this is a default. My fault. It's a default. He didn't appear. Default judgment. Defendant neglected to appear. We're ready on some of yours, Mr. Gaith?
Yes, we're ready on all of them.
Good. Hang on one second. I'm gonna come to you right now. Kellyanne Ferguson. 19R 511 211 20R 511 787.
Good morning, Judge. Madison Gator, on behalf of Ms. Ferguson. Ms. Ferguson, state your name.
Kelly Ferguson.
Why didn't you show up for your pre-sentence report?
Judge, is this the 19 case?
Yeah, but she was in front of me, May 15th. I gave her a personal bond. I said, we need a pre-sentence report. And then they said they sent a notice to appear with rescheduled date for updated PSI. Notice for March 23. And she never contacted the court. Why not?
Judge, Ms. Ferguson has a number of medical issues, severe medical issues, not to go into detail.
I don't need you to. I'll just get a PSI right now. How's that? On that case, we got this other one from 2020.
That one we're requesting, the prosecutor is requesting some discovery because he doesn't have any specific.
I don't have any problem with that. I'm gonna go ahead and sign the discovery order. We're gonna reschedule that one. Lisa, maybe, let's see, this is Rockwood, both of them, so I could schedule the one for sentence and the other one for pretrial.
June 12th at 8:30.
June 12th at 8:30. Ma'am, listen closely.
Judge, Ms. Ferguson's having surgery on the 11th.
Okay. Do we have like, what, the 26th, Lisa? Or no, I won't be here, will I?
The 26th at 8:30.
But I'm not gonna be here.
I don't.
Oh, wait
no,
a
I
minute. Yes, I am. No, that's the 30th. Yes. The 26th at 8:30. My apology. 26th at 8:30. So here's what I'd like you to do. Go down the hall, get your notice. Do you work, ma'am?
No, I have an interview today.
All right. Here's what I want you to do. Go down the hall, get your notice for those dates. Then you're going back over to the probation department. You have to go over across the hall to probation for a PSI on that case. Do you understand?
Yes.
So they're going to interview you and they're going to prepare a report and recommendation. And you'll have a chance to review that before your sentencing on June 26th. Do you understand all that?
Yes.
Any questions?
No.
All right, best of luck. Jeremiah Mitchell Davis, 25F243817.
Good morning, Judge. Madison Gator, on behalf of Mr. Davis.
Your name?
Jeremiah Mitchell Davis.
So this was a plea to child neglect,
Correct.
and he left this 5 or 6-year-old child, 5-year-old child in the car. He was, I said I just wanted to read the report, set a sentence date, and there was an agreement to be taken under HIDA, so I'm gonna go ahead and listen to whatever you have to say.
Judge, just that, Mr. Davis, this is a first offense for him. He's got no criminal record whatsoever, Judge. He works 2 jobs to try to provide for his son. Obviously, he understands what he did was wrong, and this was an oversight on his part and will never be repeated again. Am I correct?
Correct.
Anything you'd like to say?
I apologize.
Well, don't apologize to me. You gotta use your head.
Yes, sir.
You're leaving a 5-year-old and the police were able to get in, right?
They were.
So what would have stopped anybody else from getting in? Hang on, listen to me. What would have stopped anybody else from getting in and taking your child?
Nothing.
I know, so you gotta use your head. Okay? Now that you don't seem like a malicious guy here, but you can't be leaving a 5-year-old unattended in a car for better than 10 minutes. Bring the child in. I know you get to buckle, unbuckle, I get all that. But you can't do this. Now, I'm not gonna make a major issue of this, but I certainly hope that you've learned a lesson.
I did.
6 months probation, you cannot leave the state without the consent of the court or violate any law. Change your address, your place of employment, or home telephone number, you must notify probation. Look, I could order parenting classes, I could order I'm not gonna do that. I see that you're raising the child on your own, right?
Me and his mother were doing week on, week off, but he's primarily been with me for 4.5 years.
Well, wait a minute. Yeah, that's what I mean. I read in here somewhere that you've been, she's not been around to help take care of him in about 4 years, you said. Is that true or false?
She has not been around for most of the time. She was like in and out of the picture. She had left like the state a couple times, and I was primarily with them. My sister helped me in the past, but other than that, it's been me primarily.
Where do you work?
DoorDash. And I also have a job I'm starting to student wing some paperwork for Bella Bathrooms as a salesman.
I'm gonna place you on probation for 6 months. They left at my discretion. I'm taking it under HIDA. You cannot leave the state without the consent of the court or violate any law. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. Serve 16 hours of community service by July the 20th. Pay fines 100, cost 50. 75 victim's rights fee, $50 justice assessment, 40 in attorney fees. 435. 435, do 2 days community service. I'll give you a review hearing date. You complete your community service, you pay your fines, you come back, the case will be dismissed. Give me one about 6 months out, Lisa.
November 13th at 9 o'clock.
November 13th at 9 a.m. Listen. This kind of scares me. Okay? I don't want to make a big deal about it. I hope you're going to use your head. All right? Do you have all of this to pay?
You said
35.
Is there any way I can make payments?
Yes. How much do you have today? Anything or not?
I don't have any cash or anything right now. I only have like $90 in my bank.
When can you pay this?
If I can pay like every 2 weeks.
How much?
100.
Okay. 100 bi-weekly. When do you want to start?
Probably within the next 2 weeks. Like I'm saving up for a place.
Good. Okay, I'll tell you what, I'm going to give you some slack. June 20th, you start to pay 100 a week. Now listen to me very carefully. If you don't have the money, no problem. Call the court. We'll go on Zoom on or before the due date, or you come in here at 8:30 in the morning on or before the due date. Be glad to give you an extension. I'm so easy with that, and yet people don't want to take me up on it, and then they end up in trouble. So all you got to do is show a little bit of respect, just a slight amount, okay? Good luck to you. Wish you well. Thank you. And you're going to meet with probation, by the way, before you leave. Okay. Andrea Danielle Rich, 25F 243-816.
Good morning, Judge. Nancy Gates on behalf of Ms. Rich.
Ms. Rich, your name.
Andrea Rich?
All right, now this one scares me.
I know.
Well, I'm just telling you. I don't want to make a mountain out of a molehill, but you scored almost a 2-0 on the blood draw. You're not even legally able to drink. Now, I don't keep statistics up here, and I'm certainly not going to go research statistics that I'm going to know are not probably very reliable. But I'm telling you, I've been doing this long enough to know that when people have this kind of breath or blood result, guess what the likelihood is that they're coming back in front of me or another judge, either in this court